I'll call the meeting to order. I'd like to begin by acknowledging that we are in Treaty 1 territory and traditional homeland of the Métis Nation. I'll introduce the panel members and the Secretary of the Board and the Assessor. I'm Marcel Larondo. I'll be chairing. Cynthia Stevens is with us. She's on Zoom. Maurice Terrien is to my left. Our Assessor today is Jeremy Poole. Our Secretary today is Michelle Napin. To the participants of the hearing, please note that you are placed in the waiting room until your property is called upon. When it is your turn, you will be admitted into the meeting. Kindly follow along with the City of Winnipeg Board of Revision YouTube channel for the hearing process. Once the host admits you into the hearing, please close or mute your YouTube player. You will then be permitted to speak with respect to your property. Once your hearing has concluded, you can leave the meeting. We will be hearing applications for revision of assessment roll in accordance with the Municipal Act. The matters for which revision is requested have been described in each application, and we will limit the discussions to those matters. The statements that are made at this hearing are sworn testimony, and anyone speaking to the matter must be sworn in. Be advised that comparisons of assessment of properties are not considered evidence of market value by the Board of Revision. The Board of Revision is appointed annually by Council and is independent of it and the City Administration. It makes its decisions on the basis of the evidence provided at this hearing and issues a written order that will be mailed to all parties as soon as possible. Please note that the Board's decision with respect to an application may be appealed to the Manitoba Municipal Board if the matter pertains to assessed value or classification, or Court of Queen's Bench if the matter pertains to an application of exemption from taxation. Should you wish to appeal, information on how to do so will be included with the Board order. With respect to the hearing process, I will confirm the points of appeal with your property to be addressed with each applicant following the swearing in. We will then have the assessor's testimony followed by questions that the applicant may have, and then the applicant's testimony followed by questions. Each side will have an opportunity to summarize if they wish. Once all the evidence about an application has been brought forward, the applicant may leave. The process will repeat for each item on the docket today. The session will close after all the applications have been heard, and the Board will deliberate in private and make its decisions. You will receive the Board's decision by registered mail as soon as possible. As information, all public hearings are live stream recorded and will be part of the public record. First file up today will be 704 Osborne Street. So, yes, Jeremy, and let's swear them in. Okay.
Mr. Poole, can you state your full name for the record, please?
Jeremy Ryan Poole.
And do you affirm that the evidence you're about to give at this hearing should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Okay, roll number is...
Sorry.
We're going to swear Ryan in first.
I got to find Ryan. Ryan, there you are. Sorry, can you state your full name for the record, please?
Ryan Miles Oliveros.
And do you affirm that the evidence you're about to give at this hearing should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And Ryan, if you can let me know when you want me to hand out the rebuttal information you submitted.
Sounds good.
Okay, thank you.
Thank you.
Jeremy, when you're ready.
Property roll number is 12-001074000. Address is 704 Osborne. For the 2022 assessment cycle, we have an assessed value of $537,000. If we turn down to page, will be on my page 8. This is an order from the Board for the 2020 cycle. Obviously, this year has been extended to encapsulate the value that would be in 2020. So we have an order here. I reviewed the order. After review, the decision was based on the net operating presented by the Assessment Taxation Department with a capitalization rate of 6.775. So the reduction was from 584,000 down to 537,000. Below is the brief attached that the assessment department submitted. I apologize. The pictures didn't turn out. I'm not sure if it was just an imaging thing. I don't think there's any issue with sure is not turning out. There's enough in the appellant's brief that we can go on in my brief as well. As we go along, we see that the workup is on my page 16. Originally, it was a $13.49 for the 2,580 square feet. And in the basement, it's a substandard basement. We had a value of $3.96 a square foot, 1,520 square feet there. So for the total of 4,100 square feet, we had a potential rent of $40,823. We had our vacancy loss at 5.5. Our effective gross income would then work out to be $30,577. Our expenses are at 2%. We all know the argument that the appellant and agents in general feel it should be at 7%. I don't think we need to belabor that argument. We heard it quite a bit. Every panel member knows, and every agent knows that. So just pointing that out. Shortfall is at $7, which works out to be an NOI of $36,226. And then, of course, we had it capped at 6.2, which would have produced the 584. So the board ordered an adjustment in cap. It led to reduction. After reviewing the comparables and reviewing the data that was submitted, I feel that the reduction is fine, that it should be followed. We're honoring the board's orders unless there's a significant error. Could be by either agent or assessor or the board itself. But aside from that, we'll be department-wide honoring the decisions that come from the panel from the cycle for this year. So after review, I think the 537 is appropriate. It's been ordered and we're maintaining that today. So,
Ryan, you got any questions?
I do. So, Mr. Larendo, did you want me to open up with the questions, then submit my rebuttal, or did you want me to present my rebuttal first and then move on to questions?
Do your questions, then we'll do the rebuttal, okay?
Okay, sounds good. Mr. Pohl, have you inspected the subject property?
no, I have not. Just through pictures.
Through pictures, okay. All right. So are you aware of the accessibility concerns as well as the limited parking for the subject property?
Yeah, the parking is obvious on the exterior, and there is no elevator leading to the second floor.
Okay. And you're aware that there's a stairwell that's connecting the front portion of the building as and the back portion of the building that was built in 1969, I believe that was?
It's an older building, yes.
Yes, okay. All right, so with regards to your cap rates, so just to be clear here, you have on page 4 of your report here a cap rate of 6.2%. Are you agreeing that the Board of Revision's order applying a 6.75% cap rate is fair in this case?
Yes, as you see the value, that was the original value. We have adjusted that. We're just putting the board order in. So this was what was originally done. So
okay,
that's what I'm saying is that 6.2 cap rate is not being applied here today. We've taken the board order and we put the value of the board order for this given year. So.
Sounds good. Okay, thank you. Those are my questions.
Boris, any questions?
Well, I'm just looking at your the cap rates on page 6. I would assume it's under office.
Correct.
Is that correct?
Correct.
Okay. And so originally the city had used 620, now you're at 675. So is that a suburban A type of office? Is that I'm trying to find out where it fits in that category.
No, it'd be more of a suburban B, which would be between 6.2 and 7.3. Given the year and the size, it'd be a little bit smaller. Basically, there'd be more demand for it, so you'd be able more competition for it. It's not such a large property that you'd only have a few players that would purchase it. A lot of owner-occupiers or investors would be able to purchase a property such as this, so that would lead to a lesser risk there because there's more of a buying market. So, but again, the board ordered a 6.75 cap, and that's the one we.
Yeah, Jeremy, just a comment. When you're speaking, as you keep going, your voice keeps going down and it's more of a mumbling
Okay,
as
so
you
I'll
proceed.
try to be louder. I don't know the mic picking up on your end.
Comment so that we can get all what you're saying.
Sure.
Thank you. That's all, Mr. Chairman.
I've got no questions, but Ryan, you want to go with your rebuttal before you make your presentation? Is that what you're saying?
Yes,
Okay. Go.
that's correct.
I will email it to you or put it in your folder. So Jeremy, I'm just trying to email it to you right now.
Okay.
Where is it?
At your, I guess it's your city email address.
I'll wait. Hold on.
So would that be at the bottom somewhere? Here?
Just give me 1 second, Maurice.
Right.
It's not there yet.
Got it. Just give me 1 second.
Okay, good.
Michelle, did you send it to me too, or do I have it already?
I did. I sent it to that same email.
Oh, you did. Okay, hang on 1 second.
Give me 1 second.
Okay, you tell me when.
I will.
So we look at the bottom here, Max.
Yeah, somewhere at the bottom there.
Somewhere at the bottom.
I'm not sure which one she sent, putting it to.
We'll see.
Probably in that little file.
I got it, Michelle. Thank you.
Perfect, okay. Okay, so for you to go to the bottom of the file folder.
Yeah.
Click on it.
Yeah.
Oh, there you go. No, double click on where it's red.
Mhm.
Oh, this one.
Yeah, open it first.
On the Acrobat Reader one?
It says hearing evidence for board. And
Yeah, I saw that.
No. Click on that. Oh, yeah, click on it.
This one?
Yes. There it is
Oh, in
right
here. Okay, thanks. Thanks, Michelle.
So everybody has it now?
Yes.
Good.
Okay, so we're all good to go?
Go for it, Ryan.
Okay, sounds good. All right, so my rebuttal, if you look on page 2, or sorry, looks like one of the pages didn't get numbered. I apologize about that. So to make it clear, comparables 1 to 4 that the assessor has presented today in his evidence on the appendix, in his appendix, those are post-reference year leases. So I do ask that the board strike those out in their consideration for value today. And with regards to the remaining comparables, now the assessor has provided an abundance of comparables for us today. I'm not going to go through every single one, but just to draw your attention to, to a number of them. You can see the photos that I have for the properties. Many of the comparables that the assessor has used today have superior parking access, egress, parking availability. They also, in my opinion, based on the photos that I've seen of the exterior of the comparables, they are more accessible than the subject property itself. Now, with the subject property, I'll get to it in my presentation, but there are accessibility concerns with it. So pages 1 to 50 of my brief, those are the comparables for the suburban, for what I believe is a Class S office space, and from pages 51 to 60, they are for the medical office rents. So again, I just want to make it clear that the assessor is using comparables that are, again, greater with their land to building ratios, as well as their parking and accessibility concerns. Again, I can't go through every single one, but after reviewing the assessor's comps, and in my opinion, the best comps that he used for a suburban office is comparable number 5, which was applied a rate of $10 per square foot. It's Similar in terms of accessibility, we can see on page 5 that the front entrance, there's a stairwell there. It will be difficult for a person with limited mobility to enter this property, and I am not sure if there is an elevator, if there is elevator access with this property. And the rear entrance, you can see, could have gotten a better photo there, but there is a step leading to the rear entrance as well that limits its accessibility, as well as the parking. We can see that it is inconvenient for the tenants of this office space, where if somebody who's parked near to the building needs to get out, one person would have to move their car out of the way. So again, the main concerns being the accessibility, parking issues, and the higher line to building ratios of what the assessors use for his comparables today. And that would be my presentation for my rebuttal.
Okay, any questions, Jeremy?
Bear with me 1 second. I just lost my feed from my end. Just give me like 30 seconds. Okay. Apologize. I've been losing my feed all morning, so it's a little inconvenient here. Okay, so you're claiming, or you're trying to explain that the lack of parking, or your perception of lack of parking, will affect the tenancy of this building, meaning not as many people will want to come in as a client. Therefore, there'll be a lessening of economic opportunity on the site. My understanding be correct?
That is correct.
Okay. So why would there not be enough access parking on Baltimore itself? It's a side street. There's no restrictions. You could park anywhere.
Yes, that is true. But again, one of the major concerns is the limit accessible is for persons with limited mobility. If you can't park near the building and it's very busy, it'd be tough for a person with limited mobility.
But on Baltimore, there is ample parking. You don't have to pay. There's also parking on Osborne, but just the residential street leading off there, there's more than enough parking. The use of the building itself is a dental office, correct?
That is correct.
It's a smaller dental office. You typically staff would be 10, maybe 15 people max, given the size of the CRU.
I believe so. I think my client for this specific property has less than 10 for the subject. Their operatories that they have in there would probably be about 6, maybe 8 at most. Yeah, I would agree with that.
Have about 8 clients in there, maybe a few more waiting.
Mm-hmm.
It seems like there's more than enough parking on site and with the residential street next to it, as well as what you might have to fight a bit for parking on Osborne there, because there's more obviously up front, demand up front. But that would be more than enough for this given use of the property. It's not like it's a theater. It's not like it's a higher volume use where you would need a multiple people within the building at any given time. There's probably less than 20 people in this building at any given time.
Yes, but there are also surrounding buildings, and then I actually inspected the property twice, and I did have to park quite a ways away from the subject building itself. So again, just going back to the fact that persons with limited mobility, aside from the interior of the building itself, would have trouble.
Okay, I appreciate that. I appreciate people who have limited mobility, no issue there. Mm-hmm. But of the people that walks in, how many do actually experience limited mobility? This is not like a building that caters to people who have that need help, semi-dependent living, or cater to cane. When you get older, you need canes, you need walkers, you need other accessible equipment to help you get around. That's not the clientele base here.
I mean, I believe that people with those mobility concerns do need to come into a dentist office as well. So
overall, the 2 points that you're pointing out is parking and mobility. of the clientele base for that business and any businesses that would be occupying it, with the exception of a property, a business that is catering to limited mobility, people living with limited mobility, is a relatively minor point.
I mean, in my opinion, I wouldn't agree with that. With when you're coming into a dentist office, you have people of all the different physical capabilities coming in. So
That's all the questions I have.
What is?
Well, I guess your main point here, well, I know.
This is on his rebuttal rate.
Yeah, I know. You got 4 post-reference. I guess that's your issue. I guess the rest, there's a ton of examples. I guess we'll have to wait for your presentation. Is that your main point? The 4 post-reference?
no, my main point is that the comparables that the assessor, that the model is using today is that many of the comparables that are being used do have much higher land to building ratios than the subject property, and they do have better, in my opinion, they appear to have better accessibility than the subject.
Okay, but my other question is when this was appealed and dealt with in April, early 2020, wasn't that all dealt with, the comparables? Or am I mixed up on dates here?
I don't believe, based on what I heard from listening to the hearing back in, that was October 2020, I believe. I don't believe that the accessibility concerns, the land to building, the superior land to building ratio were brought to the board's attention at that time.
Okay,
So it was those concerns. I do understand that the comparables were addressed, but I did want to point out more specific facts regarding them.
Okay, thank you, Mr. Chairman.
Ryan, some of the comparables that you were wanting to put out were not the ones that the assessor was actually using. I mean, he colored them in. He used 18, 19, 43, 44, 48, 55. Do you have any problems with those ones that he chose? Maybe I missed something in your rebuttal, but you were picking on some of the properties he hadn't chosen.
Well, my understanding of these tables, I understand that the assessor highlighted them, but my understanding was for the assessor just put more emphasis on those comparables that have been highlighted. But maybe I have a misunderstanding. Are these comparables not all taken into consideration in the model, Mr. Paul?
Can I just since you're addressing it, I'll do it briefly. This is a standard table that I prepared. I prepared pretty much a lot of the rents that you see at appeal. Other assessors review them. They go over them. They may include or rule out a few, or even add in a few. It's a starting point to the marketplace. There are 65 comparables here. If you look at the that you have in question, they range from $11.75, $15.25, $15, and $12.50. If you remove those or even average those out, it comes right back to about the weighted average that we had, about $14. So when you're working with a large populace of rents, it's statistically, if there's an error in one, it doesn't change that outcome. If you look at the average, it's $14.06. You look at the weighted average, it's $13.86, and you look at the median, it's $13.75. That's a very tight range, which gives you a fulsome marketplace review. At this particular point, you can review it and say that comparable is most likely. That one's more. You can put weight on any individual one you want, but we're bringing in the general marketplace as a starting point. Obviously, the assessor, Mr. Arkluck, reviewed 6 that he particularly felt was more important and highlighted them. But as far as the post reference, which I can read it. There's one that starts in May, 3 that start in May, and 1 in June. I don't know when those leases were signed. That could have been prior to the actual date that we have there. It could have been an error. Could have been, but that would not shift the overall average, weighted average, or median because we use such a large populace. The danger of using 5 sales, 6 sales, if you look at 5 or 6 outliers, or a couple could be wrong in there, it could shift your number quite a bit. When you're actually looking at a large populace of sales here, you get a pretty robust outcome when you see those 3 variables very tight together. So it's a good analysis.
Ryan, you want to
Yes.
move on to your presentation?
Okay, Marcel.
Oh, I'm
Cindy,
sorry.
Cynthia.
Yeah.
Cynthia,
I have a
you weren't
question.
sitting here.
I know, I'm being nice and quiet here. I just, one question, Ryan. You said, you've indicated that you think the best comp on here is number 5, correct?
Correct.
Yeah, okay. And if I'm reading this correctly, that this particular lease is for the upper floor only?
Yes, that's correct.
Okay. And in the case of the subject property, they have the entire building, is that correct?
They have the entire building, yes.
Yeah, okay. Thank you. That was all my question. Thank you.
Now, Ryan, you can go on to your presentation.
Sounds good. Thank you very much. Okay, so the subject property, 704 Osborne Street, realty roll number 12-00107-4000, file number 21-217. So we are asking this board, going on to page 2, to reduce the assessed value for the subject property from $537,000 to $435,000. You can see a photo of the subject right below my summary as well. So going on to a description of the property. So the subject property, it's best described as a commercial medical office building, and it is an owner-occupied facility currently being operated as a dental clinic. It is located on the northeast corner of Osborne Street and Baltimore Road. The subject building, it's a part 1-story, part 2-story structure with 2 basements. The gross building area is equal to the leasable area, measuring 4,100 square feet. So the front portion of the improvement is the original 2-story wood frame structure that was built in 1942. The main and second floor both measure 880 square feet for a total of 1,760 square feet. We have ceiling heights. I measured them. The main floor is approximately 8.3 feet and 7.9 feet for the second floor. The main floor is what's being used as a reception and waiting room, as well as storage. The second floor is used as office space and an employee break-in with a kitchenette. The basement of the original structure is 700 square feet with a ceiling height of 6.8 feet and is being used as storage. The rear addition, which is also wood frame, was built in 1969 with an above-grade area of 820 square feet and a ceiling height of 8 feet. It is used for the patient rooms, for the day-to-day, and the rear portion that was built in 1969 are the patient rooms that's used for the day-to-day dental operations. The 820 square foot basement of the addition has ceiling heights ranging from approximately 6.4 to 7.2 feet and has a small portion that is currently used as an X-ray station, but is predominantly used as storage. Now, I've provided an abundance of photos. I'm not going to go through every single one. On pages 15 to 53 of my brief. And there's also a map of the subject on pages 4 to 5. So I am going to bring your attention to a few photos. So there is no elevator access to the second floor or the basement X-ray stations. Furthermore, there's a small staircase connecting the reception and waiting room, which is the original structure, and the patient rooms, which is the rear addition, with no ramp leading to those patient rooms. So now this does bring me back to my point that there are accessibility concerns for persons with limited mobility. Now, to show you what those accessibility concerns are, if you go to page 32 of my brief, we can see on the left side of the picture here, there is a staircase leading to those patient rooms. So again, we're leading into some limited accessibility for the subject building, as well as on page 42, just to show there is no, sorry, not page 42. Page 28, the stairwell just leading to the second floor, and page 42 is the stairwell leading to the basement X-ray stations. Again, in our opinion, this building being classified as a commercial medical office, there are accessibility concerns for anybody. You have persons with physical limitations coming into dentist office. Everybody, many people. We have all different types of people with different physical concerns that would come into a dentist office, not just. We do have a number of people coming in with physical concerns. Okay, so going to page 8. So when we first reviewed the property, we understood that the assessor was going to be supporting the revised 2021 assessment. That was $13.49 a square foot, applied to the 2,580 square foot area above grade level, which includes the entire main floor and second floor, and the basements totaling 1,520 square feet, which have been assessed at $3.96 a square foot. Okay, so we do not dispute the model rent applied for the basement. However, we submit that the overall model rent applied for the areas above grade is too high, and that different rental rates should be applied to the main floor space as well as the second floor. And just a point that I forgot to mention here regarding the property, we have a low lot to building ratio of approximately 1.6. The land area is 2,728 square feet, and parking is limited to 4 vehicles. Just going back to page 4, sorry about that. Again, we could fit 4 cars here, but then in order for the cars nearest to the building to back out, the cars to the rear would have to move the cars in order to get the other vehicles out. So again, it is a limited space. Okay, so going back to my rent, again, we are suggesting that different rates should be applied to the main floor as well as the second floor. We're suggesting that based on the precedents that the Manitoba Municipal Board has established on Municipal Board Order A-05171, that a rent on a second floor space should be adjusted downwards if that space has no elevator access. So on the Municipal Board Order for the 2003 appeal of 720 Taylor Avenue, it states on pages 5 to 6, which are pages 67 to 68 of my report, the board states, the board therefore is inclined to accept the assessor's submission of $11, but with one adjustment for the lack of elevator, and further states that an elevator is necessary to make the second floor marketable as office space for most prospective employers. So the municipal board accordingly adjusted the rental rate for the second floor downwards to a rent of $9 per square foot and $12 per square foot for the main floor, and $12 per square foot for the main floor. We are not suggesting that the rents applicable to 720 Taylor Avenue are applicable to the subject property in this case. The appeal for 720 Taylor Avenue was for its 2003 assessment with a 1999 reference year. The building is also much newer than the subject building with a construction date of 2003, whereas the subject, as stated earlier in this report, was originally built in 1942 with an addition built in 1969. We are suggesting, however, that the municipal board's rationale be applied for the subject property, which is to apply a lower rent to the second floor office space with no elevator access. For 720 Taylor Avenue, that rent equated to approximately 75% of the main floor rent. So we therefore submit that since the subject building has no elevator, that a lower market rent for the second floor is warranted. The property is owner occupied, so we did have to conduct market research to identify lease comparables for the main floor dental clinic and the second floor office space. So going on to page 9, you can see my comparables there, and I've provided photos of my comps for the main floor starting on page 54. The rental rates, the rental rates range from $13.49 a square foot to $15.18. The rental rates range from $9 a square foot to $13 a square foot for the main floor, and the areas range from 484 square feet to 2,458 square feet. In our opinion, the comparables that we've presented today, based on the photos that we see, we can see, in our opinion, that they are superior in terms of accessibility and superior in parking availability and parking access egress. For the second floor, we have rents. We've provided 5 comparables here. They range in size from 476 square feet to 1,376 square feet. Rental rates from $9 a square foot to $12.22 a square foot. Indexes number 2 to 4 have no elevator access. Index number 1 does have an elevator, and I was not able to confirm if index number 5 has an elevator. So based on the above, we have applied a rate of $12 per square foot to the main floor over the 1,700 square foot area and $10 per square foot for the 880 square foot second floor. So we do not contest the overall rent being applied to the basement again for $3.96 a square foot. And this brings us to a potential rent of $35,219 per year, or $8.59 per square foot overall for the 4,100 square foot area. We're not contesting the vacancy allowance. We do not contest the shortfall rate that the assessor has applied. We are reapplying the 5% non-recoverable expense allowance. I understand that the board, as well as the assessor, has heard this multiple times, so I'm going to skip through that. The non-recoverable expense study is available for your viewing if you so wish. And for the cap rate, we are applying the 6.75% cap rate according to the board's decision, which I have included in my brief on page 70. So based on our analysis, applying those value parameters, we are asking this board to reduce the assessed value for the subject from $537,000 to $435,000. And that is my presentation. Thank you.
Mr. Poole, any questions?
Yes, I do. I'll start off with the mobility issue with your order. I just to it here for 730, or sometimes referred to as 720 Taylor. Are you aware of this building? Did you look at this building, the 2 sales that occurred after this order on the building, or been in the building?
For 720 Taylor for the municipal board order, I have not.
Are you aware that this is a 2-story building that is a 1 CRU steel frame building built in, I believe it was 2003, approximately?
I'm aware that it's a two-story building, yes.
It's a commercial investment grade building, much different from what the subject property you have here today is. The tendency that would acquire that this building would attract, and the investor would purchase this building based on what that pay is completely different from where the subject property is. Would you agree with that or disagree with that?
I would agree with that, but the main point that I was trying to make there was the fact that a second floor office space should be applied a lower rent.
Yeah. So let's examine that. we have that property, 5,000 square feet, basically plan area over plan area, one CRU, there is no multiple CRU, there's no way to separate as it currently sits anyways, the building out, there's one tenant that needs to occupy. For that 5,000 square feet, you would have to have a number of people going up the stairways to occupy that 5,000 square feet. It is a business, and it is business on the bottom. What you have at the subject property is basically a dentist office, medical, whatever you want to call it. It's a main floor area where you have about 20 people or so occupying the building. And most of that economic opportunity occurs on the first floor. Whereas that's completely different to the second, the ruling of 720 Taylor, where it's equal on both floors. So yeah, there would be the board order to reduce that second floor area a little bit, and rightfully so. But the subject property here is not the same. So that order, I don't believe, should have any weight for the subject property. So that's my position on that. If we go over to your comparables, bear with me here. Your comparables are on your page 9. Your comparables are on Portage Avenue, Regent, and Roblin, and St. Mary's and Broadway. Your median is about $12 for only 11 comparables, correct?
That's correct.
So you are not too far off of where we are, but on a populace which is greater than what you're presenting by about a factor of 5.
Sorry, can you repeat that last statement?
You have about 11 comparables.
Yeah. Yes.
And we have 65, so we have about 5 times the comparables that you brought. Correct?
That's correct, yes. But we are trying to focus on what is comparable to the subject and apply an appropriate rate based on, I guess, and I do believe that we are applying an appropriate rate based on the operations of what is going on the main floor of the subject.
Median $12.
Yes.
And two of those rents are right at $13, which is basically the same as what we brought in at $13.86, a median or so. And you're at 12, 12, 12, 12, 12, and then you have a couple lower ones at 9 and 10 and 11 and 11.49. So where is the significant differentiation to get down to 850, I believe, 859? Is it reliance on the second floor reduction?
It is. It would be majorly. It would be on the second floor reliance, correct?
Okay. And lastly, how many operatories are on the second floor? How many operatory? If you're in a dental office or any medical office, operatory would be considered your little closed area where they work on you, whether it's dental related or other. How many are on the second floor?
How many are on the second? There are no dental offices on the second floor. So those first rates that I've included there are for the main floor office, and the second table would have been for the second floor office space.
So for the operating practice of a medical dental office, it's pretty much administration, storage, your medical supplies that they're using up there, and inclusive in the basement as well. And your main floor is where your clients would be serviced and in.
That's correct, but then you would still have the staff needing to use the office space as well. So,
That's all the questions I have.
Okay.
That's it?
Yep, that's it.
What is?
So just to confirm, the dentists work on the main floor?
yes, that's correct. That's where all the dental operations take place.
Okay, how many dentists work in that office?
To my knowledge, it is just the owner, but I actually did not ask that question to the owner.
Because my question relates to activity, and you said there's 4 parking stalls with the building?
That's correct, yes. And
there's one dentist, but obviously there's assistants. But that's, okay, I wanted to see the scope of the operation, I guess. Now, you're at 859 from what I can see, blended, versus the city's at 1102. So your main arguments are, again, the accessibility and the parking issue, correct?
That's correct.
That's all, Mr. Chairman. Thank you.
Cynthia?
Just one question, because I think everything else has been covered for me. In terms of the comps that you provided, would you see the visibility and location of this property as having any effect on the rent? I mean, it's in a high traffic area, right on the street, where some of these other properties are set back more.
No, I don't believe that there'd be any visibility concerns. I understand that the comparables that I use do have a larger setback, but they are larger buildings as well. So multi-tenanted offices, medical offices.
Okay, thank you. That's all I had.
Which page number was your workup on? Ryan?
My workup is on page 11.
I don't know why I missed it. I did. Oh, that's this. Okay. You had. Okay, got that. No, I'm good then, Ryan. That'll conclude that matter. Anything in conclusion, gentlemen?
No,
Ryan?
I think we've covered all the facts as well.
Okay. Jeremy?
I'm good. Thank you.
Okay, thank you. That'll conclude that matter. We'll get back to you at a later date. We're going to move on to file for 34.
Thank you very much.
Thanks, Ryan.
Thank you.
3401.
I think I lost the feed.
Yeah, well, I can see you, Jeremy, but
Okay.
I can't see anybody else. And I can hear you.
We can take a break, and we just got to work through it, just the way it works here, or like virtually, I guess. It's all good. I think we got kicked out.
Yeah, I think that's what happened.
Okay, I'll give it a minute and let them reset or whatever they got to do.
Okay, host, I unmuted. Where are you? Yeah.
Okay, good.
Yeah, Rocky's there.
Oh,
Oh, our assessor's gone.
The assessor,
The assessor.
Cynthia, there you are.
I'm here. Yep.
Jeremy's back,
Okay, so I can swear the applicants in if you like.
please.
Mr. Neufeld, can you state your full name for the record, please?
Rocky Neufeld?
Do you affirm that the evidence you're about to give at this hearing should be the truth, the whole truth, and nothing but the truth?
I do.
And Mr. Mercury, will you be giving evidence as well?
Yes.
Can you state your full name for the record, please?
James Mercury?
Do you affirm that the evidence you're about to give at this hearing should be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Jeremy, you're up.
I believe it's only quantum quantum's not on at appeal here, so class and liability would be on the appellant.
I don't see it.
There was liability classification and quantum that had been checked
Kicked
off.
off. You get that, Jeremy?
Oh, sorry, I saw on the application that it was just highlighted classification and liability. I thought maybe the quantum was no longer being sought. Okay, all right, fair enough. Bear with me here. Okay, roll year is 2022. Roll number is 0100093090 for 3401 Roblin. The roll year is for the 2022 roll, or assessment roll, or assessment year. Assessed value is $1,532,000. If we just skip down to page 8 and 9, there is an order from the board for the 2020 cycle, which dealt with the liability and classification and amount, quantum amount. As we can see, it was handled by Colliers and Johnny Spacek. We see that the order, as it is, it was confirmed, and that there was no change to classification or liability. I can go through what was presented at that time. That will start on page 10. This is Johnny Spacek's brief. It's a building built in 1973.
Where's the numbers on these pages? Because I don't see any.
No, they're further down, hard to find.
Sorry, it's page 10. I guess I'm looking at the PDF number, but I don't know how you guys are seeing it on yours. It's number 1 of Johnny Spacek's 2020 brief.
Oh, down here, there's numbers. Okay,
You
that's
go-
pictures of buildings.
You've got to go further down. 1, and then you keep going, from what I can see.
5. No, we already talked about a page up there that didn't have.
Well, there's 2 briefs, right?
There's my brief, and then the order, and then the following brief that came from that order. And given that this is a year that was carried forward, the 2020 order I'm reviewing, as well as the information we submitted. So
Okay, carry on. I'll try and follow.
no problem. I can wait. But it's a 2-story building. Gross floor area, leasable area is about 10,150 square feet. Pictures are on the next page. My understanding is some of these pictures didn't show through. There's an image issue where I guess PDF didn't make it to your guys' way. I apologize if they're not showing up, but it is a 2-story building. It's unmarked. There's no signage on it. There was a sale sorry, my mistake. There's a sale May 17, 2016 for $1,850,000. Our workup that was submitted for the 2020 year is on page 5 of Johnny Spacek's brief. It is $12.15 a square foot for the COU, which produces a potential rent of $123,323. Vacancy at 5.5. Gives us effective gross income at $116,540. Expenses at 2%. Again, we have 2% versus the 7% argument from the tax agents versus the assessors. We're not going to belabor that again. Shortfall is $7 to get a net operating income of $110,301. Our overall cap rate was 7.2%, which produced the value of $1,532,000. So our market analysis is a little under what the actual sale was in leading up to the reference date in 2016. Our comparables are on the following page that were used then. The average is $13.87, $14 weighted average $14.44 with a median of $40, and those are all on Roblin. So it's my understanding it is leased out to Winnipeg Regional Health Authority for, I think it started in 2000, I need. Bear with me, let's scale it up. Winnipeg Regional Health. All right. There we go. They've been occupying it since 2000 and, well, on the INE since 2014. So I believe there's a lease submitted as well that the agent will get to. So it is occupied by Winnipeg Regional Health. The quantum value I feel is reasonable. It's a bit under what the sale was. The market supports it on Roblin, and I think that the quantum should be maintained based on the value that was presented in 2020 cycle and the order that was awarded by the board. So with that, I'm open to questions.
I have a few questions just on the liability portion. Mr. Dufeld, I expect we'll have some questions on the quantum.
Sure. Can I listen to your presentation? Can you reserve your questions until I listen to your presentation?
Sure.
I like to hear it. So
yeah, that's fine.
Rocky, any questions?
Yes, just a few. So the brief the evidence you're submitting today then is a copy of what was done a few years ago then for a previous year, tax year, is that correct?
the 2020 cycle, yes, that's the brief that was submitted.
Okay.
And the company order that came from.
And the rentable area, did you have an opportunity, did you get a copy of the lease that was provided?
Yes, I did.
And I'm just reading it here. I'm looking for the rentable area. We have a discrepancy on the rentable area. Is there, did you look at any sort of reconciliation?
No, I did not. I'm waiting to hear your presentation.
Okay. So this was done without that review. Okay. The non-recoverable expenses, we all know the story this year, but did you have an opportunity to review what the landlord submitted for non-recoverables, which is on your page 10?
Yeah, it is on page 10, but I'm looked at the marketplace. The non-recoverable arguments, either 2 or 7 or a little bit off of that, that wouldn't significantly change the value of it. And within context, we're looking at the actual sale as well, an achieved sale that was approaching the reference date. So if there's a little bit of a variance on non-recoverables, it wouldn't really play into a significant shift in value.
So, sorry, I heard you say earlier that you weren't looking at the sale. Now you're saying you're looking at
the sale. We're looking at what the market value is the actual market data. Of course, I'm going to cross-reference it against the sale that occurred approaching the reference date.
My question had to do with non-recoverables. Does this property not have significant non-recoverable costs that exceed the allowance that the city has chosen for this year?
Yes, from what the INU show, yes.
Okay. And in regard to it as an investment property, did you have a chance to review the theory? And I know we've been over this several times, but the reliance of institutional and sales involving institutions for reliance. Was any thought given to that?
As far as
the IAAO, which was saying for reliance on sales, don't use sales involving governments or institutions.
No, I wouldn't disclose that. At this point in time, I wouldn't exclude it from examination, no.
Why on page 2 do you have the post-reference sale price in?
Page 2?
Yes.
I apologize. That should not have been in there. That should have been redacted out. I did not catch that. I only spoke to the 16 sale, not the 21 sale. That should receive more weight from the board.
At any point, did you inspect this property?
No, I did not.
Those are my questions.
Chris, any questions?
Yes, just one. You described this as a government office. What is in there? Who's the occupant of this building?
Winnipeg Regional Health occupies the property.
The
or at least has the
WRHA,
head.
but I also saw something about school division in there, so that's why I was a little confused. So it is WRHA?
They occupy the property, yes.
They occupy the property. Okay, thank you. That's all I had.
As far as I know, at this point in time, they occupy the property, yes.
Cynthia?
No, my question was just asked, so I'm good, thank you.
Okay, same here. Let's, we're done with our questioning. Let's move on to the applicant. Who's going first? Rocky or Jeremy?
I can start, Mr. Chairman, with respect to the liability classification issue. Just by way of background, this property 3401 Roblin is one of several WRHA properties that Mr. Neufeld and I have been handling starting about 5 years ago. At that time, there were a number of appeals filed with the Board of Revision and a request for review of the classification liability status of various WRHA leased facilities in which health-related services were being provided. This was one of them. At that particular time, as I understand, there were no services being offered at 3401 Roblin. However, at a subsequent point in time, and unbeknownst to Mr. Neufeld and I at the time, or until just recently, in fact, starting at the beginning of 2017, the WRHA, in fact, was using the property for its long-term care program. And so this only came up recently, and that is why you're only seeing the application here in the 2022 appeal, not in the we didn't see it a couple of years, or the 2020 appeal initially. So that may answer Mr. Pohl's inquiry and his reference to the board order. I wasn't at the previous hearing, dealt with the 2020 appeal. Mr. Neufeld was. Mr. Neufeld can speak to that, but although liability classification had been checked off, my understanding is that there was no presentation given with respect to that specific issue, just given our understanding of what was occurring or not occurring in the building at that time. However, once we did receive confirmation from WRHA that in fact services were being provided, we did send a letter to the assessment department on October 8th of this year. And if you have the Collier's brief at page 6, this is the standard practice, is that we would send a letter to the assessment department, and the practice generally proceeds in an orderly way. You'll see it there. The letter is addressed to the assessment department. We've identified the square footage in the building. And the fourth paragraph down, you'll see that we reference the program that is being offered in the facility. This is the long-term care program and long-term care access center staff, where they coordinate services for various individuals who can no longer manage on their own without some form of support and assistance. Their workforce is responsible for ensuring clients have access to long-term care services and so forth. They deal directly with the families who are impacted. We've included, so this falls squarely under the school tax exemption provision under section 23 sub 1 sub E of the Municipal Assessment Act, which this board has heard many times in respect of various WRHA facilities. That is where the property is owned or held in trust and used by a charitable organization primarily for the purpose of giving relief or assistance to aged, indigent, or sick persons. So we've included in the material, if you go down at page 8 and following, these are just some of many examples of previous board orders for other WRHA leased facilities in the city of Winnipeg, which at this point in time have all been recognized as being school tax exempt. So we have, for example, 170 Goulet at page 8, which is an access center. 490 Hargrave, same thing. It's a leased facility in which various services are offered, as well as 755 Portage Avenue at page 12, and 845 Regent, page 14, and so forth. We've included the case law, which is no longer a matter in contention, that leasehold ownership is sufficient to satisfy the requirement of ownership under the Act. That you will find that in the Collier's brief. And then just moving along, obviously the WRHA is a charitable organization. That is not a matter of contention. We've included the actual copy of the lease, which is in page 38, starting at page 38, I believe, of the Collier's brief. The commencement date was November 1st, 2014. And the landlord is the Pembina Trails School Division. However, the services that we're speaking of today started at the beginning of 2017, and that's why there was a bit of a lag period and why this property fell through the cracks, so to speak, in terms of trying to bring it in line with the various other WRHA leased facilities. So I can understand perhaps some of the confusion at the assessment department end as to why this was not specifically addressed earlier. Just was not, that information was not made available to us until very recently. So that is in essence where we are at with the liability and classification issue, and it's certainly open to any questions that others may have. Thank you.
Rules, questions?
Sure. Okay, so just to confirm, can you please turn to the applicants? I just got to get back to the right page. Just following you there. Yeah, I guess it starts on the applicant's page 6.
Right.
This is a letter dated by yourself, or dated October 8th by yourself. You're looking for 23-1E. This property is occupied by Winnipeg Regional Health Authority. And then if you look on page 7, it says, according to the above criteria has been satisfied and the school tax exemption should be extended to the space that it occupies, being the entire second floor. That would be a typo?
That's a typo. That's my mistake. Okay. I'm not sure why that
that would be half the actual building.
Yeah, that's it. That should be clarified. It's the entire leasable area.
Okay. All right. So we're good there. What is the actual services being provided from Winnipeg Regional Health Authority? What is meaning? Is it administration out of this building, or patients or clients go into this building and receive services?
So the word services is I guess broadly defined. It's their long-term access center staff who are there and are in regular communication, facilitating the needs of and requirements of families who require long-term care services. They're not just working, amongst WRHA staff, but they're in direct contact with families. To my understanding, families can attend those offices. Are they receiving medical treatment at that facility? No, they are not. But that is not the requirement for meeting a school tax exemption. Under 23-1E, which is to provide assistance to sick persons, and obviously facilitating long-term care is, at least in my view, easily meets the definition of providing assistance to sick persons. And so We have seen various examples of that through many of the other WRHA facilities. They're not what would be described as traditional medical clinics, although there's some of that in some of the access centers for certain. But this is a matter of facilitating long-term care needs of families in need.
And sorry, I just want to add a bit to that. When the building was prior to 2016, prior to construction of the modern access center, this was a neighborhood access center. And then with the construction of the new facilities, it went vacant for a period of about a year. And then, and that's when we first appealed it, and we realized it was vacant. And of course, there's no exemption because it's not being used. Subsequently, WHA put in the current user, but for the past year and a half, it's also been a COVID center where supplies, stocking, coordinating testing. So it's actually gone into the COVID testing, which is treatment. Now that use will end shortly, and then they'll focus on the other use that was put to it, which is also covered by the exemption. That's just a bit more of the history on it.
Jeremy?
Okay. If I can get back to my questions. That letter is dated April 8th, 2021.
October 8th?
Or sorry, misspoke. October 8th, my apologies.
Yes.
Did you apply for an exemption to the department, or did you just send this letter?
This is the application process that we routinely follow now with the assessment department, and it's been established.
Did you take out a 311 inquiry and inquire?
This was sent through 311. So this letter would have been sent to 311 via email. It's acknowledged, and then they indicate it as being sent to the assessment department for review. That's how Kelly Shields has directed that we do it. And so this is the application process that we followed on numerous occasions.
Because, like, I stated before, obviously we had a series of appeals for these properties. I would prefer from my perspective, to give a chance for us to review it. Once we get a chance to review it, we agree or disagree. At that point, it could be appealed. I don't know if that's the case, given the time frame that the letter was sent, and it was sent on October 8th.
It was sent on October 8th. I can tell you, though, that
pretty tight. I don't think it will be completed in that time.
Well, in any event, I guess there was an appeal that had to be filed, and coincidentally, we're at a hearing. I can tell you we were at a hearing last week where I sent a similar letter on a very different property, and it was sent it in June, and still I didn't get a response until the assessor's brief arrived at the hearing. So I can't speak to administrative issues. This, to me, though, should not require a great deal of time in terms of an assessment department's review. As you know, the WRHA facilities have been considered on multiple occasions, and I think this was really a matter of just information, unfortunately, not being provided to us, who in turn would provide it to you. But it shouldn't be any dispute as to what is occurring there, and so it should be dealt. So we're dealing with a 22 appeal. The request is actually in respect of the current taxation year. So it certainly would be our hope that the assessment department would respond to this letter in a timely way.
And this is my point. I received it. I'm looking at it. I have other appeals. By the time I got to this, it's only a few days out from the actual hearing today. I'm looking at a review for 2020, 2021, highlighted on your next page or below that paragraph we just spoke about. And then
right.
Also this here for 2022. So there has been, to my knowledge, that this is not being reviewed independently at the same time as I'm at appeal with it. So from the timing that you requested this, there would be no way for it to be reviewed.
Yeah, I can't speak to how you deal with. I like you. I think I would prefer that this be handled on an administrative level, so that to the extent there's any dialogue that required, I've always indicated we're happy to provide or engage in that dialogue. So it just happens that it is a 22 appeal, and as a matter of due diligence, we obviously had to include this in the materials. But as a general process, I agree that the starting point is is we submit the application, and that's what we did. I think just in terms of coincidentally, there happened to be a hearing, so coming up in today, so we obviously were required to address it.
But Mr. Mercury, with all due respect, if you send something to the assessment department, and you don't ask for it to be reviewed. It may just be a letter sent to someone. By the time it trickles down, the date on the letter that you sent it and timing of this hearing doesn't facilitate a proper review of the property.
Oh, Mr. Pohl, I'd agree with you. In the past, I've sent it directly to assessors, and I've been instructed by the assessor for the city of Winnipeg not to do that. And so I'm respecting his wishes. And so he says, if you have if you would like me to do it in a different way, I'm happy to do that. But Kelly Shields has advised me to send all requests of this nature to 311.
I'm just making sure there wasn't already a review process in place. And if there isn't, I want the opportunity to inspect this property to confirm what's happened. And then I may agree with you and there's no decision the board needs to make. But
again, that's an internal matter for the city.
Gentlemen,
no, I can ask.
We don't need to be arguing about this. Let's get back on line of questions.
So I guess the question becomes: we're here. I don't believe there is any dispute as to what is occurring in the building. From my perspective, this shouldn't be a matter of contention. But that I'll leave it to the assessor to make that determination for himself. And we're before the board. I think the evidence is clear before the board as to what is occurring. The material was there. I don't believe it was filed in the brief. Material was in the brief. I don't think there was a request to inspect the property. So here we are.
So you're saying that, and I'm basically coming down to the point where I'm asking for an adjournment with an opportunity to inspect the property to confirm what's there. And then if it is so, I would agree with the rationale that you selected for the 2022 year only and not for the 2020-2021. That's a separate matter. So
the problem with you asking for an adjournment. A problem with you asking for an adjournment. We'd have to reconstitute the same board members again for this one issue. So we really need a strong reason to adjourn a meeting.
Yeah, and my point was, I'm hearing was that we sent it into the assessment taxation department through 311 to Kelly Shields, and I'm not sure if there's already an independent review being done on it at this point, but the timing that it was sent in on doesn't facilitate, it just can't be. It doesn't happen that quickly. So there'd be no way for us to review it, give you the answer back, then file appeal based on that. It sounds like there was just an appeal filed already, all points at play. And no review was asked for. It was just a letter sent. So from my perspective, sitting here as an assessor, whatever administration happened, whatever happened there, I'm trying to get this right. So if you're asking for me to make a ruling on what's going on without
number one, you don't have to make the decision. We can make that decision after when we've heard all the evidence.
Yeah.
So let's move on with the presentation and we'll make the decision after. Okay, so let's carry on, please.
And I think just to wrap this up, the 22 matter is before the board, and quite correctly, Mr. Chairman, it's up to the board to make this determination. It's not up to the assessor to make a ruling. But with respect to the 21 and 20 years, then I would ask that if Mr. Pohl is assigned this matter, that's fine. If someone else is, that's fine as well. But presumably it should be consistent with the board's order. But if they require any additional information, let us know. And it should be quite apparent from the evidence that's been provided already. So,
yeah, but the evidence you provided was on October 8th for a hearing that was already called for on today. That doesn't.
Well, it was in the brief, Mr. Pohl. We complied with the rules. This letter was in the brief. So the assessment department had it.
Just ask for the review. So this is my point. At appeal, you can do it, yes, but in proper practice, it should be asked for prior to an appeal. We give you an answer, yes or no, and then you can appeal that again.
Which we did.
It sounds like you just appealed the year itself as a general appeal and included class and liability. So
we appealed it because, as a matter of due diligence, it was required to be checked off. But we asked for a review first.
All right. That's all the questions I have.
Thank you. Monsieur Tarrier.
Yes, it's more for clarification to Mr. Mercury. You mentioned, I had the same question about administration versus actual delivery. And you told us that long-term staff is there. Now, you said the term services is all encompassing, if I understood correctly. Can you point out to me, for my own benefit, 23.1E, what does it say exactly?
Well, the bottom of page 6, I've just reproduced it verbatim.
Okay.
So 23.1E of the Municipal Assessment Act provides for an exemption for real property from school taxes where the real property is owned, and there's leasehold ownership here, by or is held in trust for and is used by a charitable organization, that being the WRHA, primarily for the purpose of giving relief, I should say or, not of, or assistance to aged, indigent, or sick persons. So the word assistance is an all-encompassing word, and certainly by providing, if somebody is in need of long-term care, and the WRHA is a charitable organization through its long-term access center staff, is assisting those people in providing and delivering the services that they need, that falls squarely within the exemption. And in fact, these types of services are provided at access centers throughout the city of Winnipeg, which we have dealt with on many occasions. So they deal directly with the families themselves. They are assisting those families to make sure that they are placed and are being provided with the care that they require. So are they being physically treated for injuries or illnesses at this facility? No, they are not, aside from perhaps, as Mr. Neufeld indicated, there may be some testing that's going on recently, but the main programming that is there is to assist families in need. And so to answer your question in terms of whether this meets the definition of 23.1E, in my view, it certainly does.
Okay, so the assistance word is broad, so that's where that comes in, correct?
That's correct.
Yeah, and the previous, I'm just trying to make sure I'm consistent here. On the previous exemptions that were given by boards, it was a similar type of situations?
That's great. Every access center is a little bit different. Some have some form of care. Some are vast majority of it is what I'll call administrative services being provided for different programming for different people. But it's all obviously for the purpose of providing healthcare services in one form or the other, whether it be the home care program, whether it be other addiction programs that the WRHA is facilitating and administering. And that we don't need to go through all of those access centers now, but each one of them is a little bit different. But there certainly is a very large administrative component to each of them. That certainly falls within the wording of the Act.
Okay, thank you. That's very helpful. Thank you.
Cynthia?
So the other examples that you provided us here, are those all access centers?
They are, yes.
Okay. And access centers, though, people are being treated there, correct? There are portions of the building where there would be treated. So I think it depends on the building that you are talking about. 490 Hargrave, for example, and I'd have to refresh my memory. I'm not certain that there are actual treatments there. There may be a small, very small component where there's treatments. I believe they provide immunizations there, but there's a large degree of coordination of various WRHA services at that site. In fact, the parking lot at 490 Hargrave is also included in the exemption. 755 Portage, there's a variety of different services there that are provided. There is a level of treatment, but certainly not the dominant portion of the building. 170 Goulet, the same thing. There is a portion of that building is used for treatment, but a large portion of the building is not. I could go on in terms of
what is being provided. But and this was a discussion we had when these exemptions first started, and we brought them before the board. I think it was in 2017, if I'm not mistaken, as to whether there was medical clinic space in some of these buildings, and quite clearly that is not the test that one needs to meet for an exemption to be provided for school tax. It's not we're not seeking a hospital exemption, for example, under Section 22 of the Act. This is a broader exemption, but a lesser exemption, and only for school tax. And that is why you see the words assistance to aged, indigent, or sick persons. If it were a hospital, and for us to meet that definition and a full exemption, there would actually have to be insured services as defined in the legislation being carried out at these facilities, and they would have to be specifically designated under the Health Services Insurance Act for us to qualify under that. And so we obviously don't meet those definitions, but under 23(1)(e), in my submission, it's quite apparent that we meet that definition in that broad language.
So just to clarify then, the exemptions currently granted to the WRHA are all access centers, and then this particular building you're adding to it based on the arguments you've made today.
They're access center staff, long-term care access center staff. So they are, in terms of what you want to call an access center. I'm not sure how that is specifically defined, but they are certainly WRHA staff who are administering programming, which is carried out in the various other WRHA leased facilities. I'm not certain that every single one of them are access centers per se. In fact, we have separately titled parking lots that actually are also subject to the school tax exemption that are form part of the exemption as well, because they are ancillary to the main building. But I don't have the full catalog of all WRHA properties that we have covered. I'm not certain that all of them, in fact, I don't believe all of them are access centers. Mr. Neufeld can perhaps refresh my memory. I don't know that they all are. I believe there was one on Portage Avenue, Mr. Neufeld, if I'm not mistaken, which wasn't technically an access center. It was a
there's one on Portage Avenue that was family services, and wasn't exempt under the Act. Also, the top two floors of 640 Main are financial administration. So we both agreed that they were fully taxable. And that's where we draw the line between what Mr. Mercury is saying is between financial administration and service administration. A large portion of every access center will deal with home care, and it will be where the home care people are located and then sent out to the various places. And one other factor is that everything's been changing, and it's very political as well, where one program ends and another program starts, and the buildings are their uses change. 5 years ago, there used to be more of the street side critical care, or not critical care, but it was the WHA opened up a bunch of storefront offices for urgent, non-urgent care. Those are all gone, and that role's been sent to the access centers. And then now there's private institutions providing the same services who are not exempt because they're for profit. The COVID has changed the usage role as well, and they've looked at space and moved people around to try to handle that. And just a few months ago, we discovered a brand new access center where we weren't even aware of, tucked inside a little place in the West End. So we are playing catch up with this, and WHA, which is now Planned Health, does change the roles, and we're trying to keep up to date with it. But essentially, we're just bringing in the properties that we know are providing services, and which is why years ago we weren't going to deal with this building, but now it's been repurposed.
Okay, thank you. That's all I have.
I guess my question is going to be around your page 6, because on here you're saying you're looking, this is just for information, this page 6, because we can only deal with the 2022. We can't deal with 2020 and 2021.
Yes, that's correct. The submission would be the same. Obviously, this letter was intended to address 21, but what for the purpose of this appeal, obviously we're not even in 22. It's somewhat of a interesting way in which the act plays out in the hearings of these appeals, because it speaks to the use of a property, and we haven't even reached that taxation year. But so that's the world we live in. But they are under lease, and this is what is being provided, and obviously this is what the intent is to provide in the year 2022. And this is the use of to which it's currently being put, and what it will be put in 22.
But you are aware that we can only deal with 2022.
That's correct. Yeah, absolutely. I appreciate that they can only be dealing with 22. The intent of this letter was obviously to set out what's happening in the building.
I just
Services.
wanted to clarify that. Yep. We're going to move on to the second brief, I guess. Will this be you now, Rocky?
Yes.
Rocky, you'll be up.
Yeah. Okay, be fairly brief on this. We're looking at, first of all, some of these issues are relatively minor. The first is that the square footage, as indicated by the owner, is 10,096 square feet. And you can find that in the assessor's brief on page 12. And it really begs the question, if you're sending out questionnaires and people will be penalized for the information if not provided or if inaccurate, why doesn't the assessor use it? This is a lease, 10,096 square feet, and the rental rate is $12 a square foot. And again, that's a relatively minor issue. The rest of the deductions from income, we basically believe that the assessor has gone completely off track with their approach to value. It's a manufactured valuation process. You can't simply say non-recoverables don't exist. They exist everywhere. The point is they're not asking for them. They're not getting them. Most companies, most professionally managed properties take these non-recoverables, turn them into a capital expense, and then write them off every year. But that's just a semantic issue. The bottom line is, if you own a piece of a property and you get your dividends from it, or you get your payments that come from the income, these deductions show up. So this isn't, we're in the real world here. You buy a property and you get a return on it. In the real world, the return will be impacted by these non-recoverables. And you can't introduce a system that does not follow the market, as the legislation indicates. As a result, it's just not a reliable valuation anymore. So we started to look at market, and for example, we differ a bit on vacancy, and the point is we used a market report, which is the Johnson report. And the Johnson report, speaking of another big factor, is transparent, because they give you several pages of all the properties they looked at and what the vacancy rates are, which is a far cry from what we have from the assessment department, where every time we ask a question about the model, it's, well, the modelers did it. So we have to go back to the market, and we have to remind people that that's what the legislation is doing. On the non-recoverables, we used a 5%, and you'll note that I pointed out on page 10 that in this year brought forward, those non-recoverables were $20,553, and our allowance is $5,661. So that's an indication that not every year you'll have non-recoverables. Now, in the past, the 2% that the assessment department used was actually for replacement reserve, and the 5% was for non-recoverables. We will use an actual structural reserve, and what we base it on is 25 cents a square foot for roof replacement amortized over 20 years. And just so you know that we're not guessing, we're not shooting in the dark here. I point out that on page 14 of the assessor's workup, which is a report from the owner, he says he plans on replacing the roof at a cost of $50,000 to $60,000. 25-year life, $2,500 a year replacement reserve. That's where we're coming from. And our calculation of the shortfall, again, another minor issue, is based on what the actual taxes are and utilities, an average amount, and the repair and maintenance, regular repair and maintenance. Now, in the lease that was submitted, you will note that, did we submit the lease? I don't, yes, I have the lease here, and I'm not sure if it was submitted, but there are differences. There are delineation of costs that the landlord bears and costs that the tenant bears. So the concept of the shortfall is what the tenant would bear, and if you have a vacancy, what is not recovered. So there are two different factors. Lastly, in terms of the cap rate, I did ask the assessor a question earlier about the IAAO, and I did send the board something now, and whether you can look at it or not, I think that the concept of rebuttal is fairly open at the board of revision. But what I sent in was the IAAO, which is listed on the assessor's page 21 as following the standards. And the standard on looking at this is section 5.3 of their verification. Sales generally considered invalid. Number one, sales involving government agencies. Number two, sales involving charitable, religious, or educational institutions. So within a mass appraisal standard, you don't rely on these, and which is why we don't rely on the sale. We don't rely on any opinion of cap rate, because the motivation on these institutional users is far different than market value. The last issue, the second last issue in the cap rate is when the city eliminated the 5% recoverable, what they had to do was ensure that all their cap rates also did not have that in it. So as a result, their incomes on their calculation of cap rates should go higher, and the cap rate should go higher. What really happened in the time period was that it went in the opposite direction. The cap rates went lower. So I do not believe that the city have adjusted their cap rates on their sales to follow through with the lack of the 5% on the income side. Both have to be done. So in a highly theoretical world, the elimination of a 5% non-recoverable should really amount to no effect whatsoever on value, because the cap rate should be adjusted. But it does not appear to have been adjusted. Matter of fact, almost virtually every cap rate used by the city comparing the current assessment parameters to the last assessment parameters went down by 5% or more. We have a number of cap rates that we had put in, and this property is suburban. Without the WHA there would not be a tenant for this property. And as a result, we believe that it would be higher. And a number of rates that we've had on page, first of all, we have a description of how we look at cap rates on page 72, suburban office. Essentially, suburban.
Carry on.
Okay, essentially suburban office, page 72. There are no Class A in Winnipeg. There are only 3 Class B, and the rest are C, D, and miscellaneous. What the assessors put on here is a Class B rate, which is an aggressive rate. but this building is not in that category. It's below that. So this is how we would rate them, and none of the professionals who put out reports track Class C, D, and miscellaneous. They only track B. So it makes it rather hard to put a market report when there's only 3. And I'm trying to think the last time one of them sold was some time ago. On our page, starting on page 76, we have some mixed use industrial, retail, office. And then on page 79, we have a few more office rents. And as you can see, they're heavily skewed to the downtown area. The last major sale that occurred was 905 Waverly. It capped at 7.93%. And that's a modern building in a good neighborhood. And when I say good neighborhood, the motivation for many sales in suburbs is by the eventual end user who'd like to have his office near his house, which in this case of that one was in a better neighborhood than Roblin. Aside from all that, the point is that a good building in a good neighborhood will, of course, cap lower. That one was 7.93, and which is why we think 8.5 is the fair number on this property in a market situation. That's my presentation.
You're going to do your rebuttal after, or that you?
That was it. I
thought
yeah, there were some pictures I sent in, and I think Mr. Mercury covered it off. And they're in rebuttal to the assessor saying on his page, I guess it's about the 5th page, where the order from the previous year, and what it is just aerial views that show the parking lot being full up to 2016, empty until 2017, and that was the period when it was empty. And I think Mr. Mercury explained what happened, how this one kind of fell through the cracks on the appeal, but from 17 forward, it's been fully occupied and in use for what it is for school tax exempt usage.
Okay. Mr. Pools, you got questions?
Yeah, just a few questions. Your appeal number, it's 194801. That would not be the appeal that we're dealing with here today, correct? On your top of your page?
Yeah. Probably not. Yeah, that's the old one. We polished it off for this one, and I guess no one changed the file number.
So when it says they're vacant, paid by Winnipeg Regional Health Authority, the school division.
Yes.
That was based on what was done then.
Yeah, we didn't change the valuation at all, our review of it. What was added to this were the legal arguments. The previous one, we were just dealing with a value issue at that time. We were under the assumption that it was still vacant.
Okay. And then obviously we have a difference between their 7% non-recoverables versus the 2%. We don't need to get into that. We've done that quite a bit. All agents have, and the board heard every argument we probably make on it. My next question would be the cap. You're using an 8.5 cap because it's a less than desirable building.
Yes, it's not a major Class B building. It's not in a great neighborhood for office use. This neighborhood is accessory use or use as office is very, very low. It's a local neighborhood service neighborhood where you're going to have stores, retail, service to the residents, not office.
In your opinion, does the tenancy of Winnipeg Regional Health entering into a long-term lease here, does Winnipeg Regional Health not typically tend to occupy at least average or better than average properties? I don't believe substandard properties Winnipeg Regional Health would secure long-term leasing.
Well, they occupy about 70 properties, and they do range. This is a historical site in terms of predating current administration and current party in power, we'll say, and it also predates the previous one in power. So it arose out of policy decisions from a long time ago. But that particular policy decision was based on reaching people. And this was a building that Pembina Trails had had no use for after they did their merger. And it became available as a local access center to service Charleswood. And it was also always intended on a shorter term, because the longer term plan was that 280 booth at the Grace was going to take this over, but then that was stalled by other policy decisions. So I don't think the quality in the building enters this on the decision making of any sort. It was adequate, it was acceptable. The point is that an investor would look at it and say, well, I like the tenant, they're AAA, I don't like the building. And we're not out to judge the quality of the tenancy here. We're out to judge the building, the neighborhood. What will happen to it when it goes dark and WHA's lease is up and they decide not to keep it? That's what we have to consider.
Okay. When they entered into their lease, are you aware that the government, or the Winnipeg Regional Health Authority, required that there was a renovation of the property, interior alterations to accommodate them? Can you describe the interior renovations that occurred?
I don't have a list of that, but I would say that is common in about 95% of all new leases. There's nothing abnormal about it.
Okay, so
but everybody has a different configuration that they need for the service they provide.
Okay. So what deficiencies in the building that has been renovated for Winnipeg Regional Health before occupying and moving in are there currently existing that would indicate that you think that it would be a below average building?
Well, I've been inside it once, and the interior is really dated. It's got what do I call them? Portholes. It looks like somebody's rec room from the 60s or 70s, and it's well past what you would see today in a modern building, and little rooms and designed for small office with a single user, whereas a modern building is going to have flex. The building doesn't have flex. If you wanted to demise it, you would be quite costly. There's the single entrance way to deal with, and then the loss of usable rentable space upon demising. So those are factors that would come in. A potential purchaser would look at it and say, how much capital do I need to convert this building to a market use? And they would likely be looking at a multi-tenanted facility. So you're going to lose space and cost money. And that's where the pessimism comes in.
You stated you inspected the building. When did you inspect the building?
I was in there in I think it was 2016, and other than that, I've only been around the outside and looking in the windows.
Were you in there prior or after the renovation which occurred? Because the renovation date of the permit is October 2016, so that work commenced. Wouldn't have been until after that. And just to inform you that the interior alterations were includes new walls, new doorways, new flooring, new carpet, new millwork, new electrical work to be suited for Winnipeg Regional Health Authority. So would you be looking at a dated building prior?
Well, my 4 visits to the site, which was 1 interior and 3 exterior, which is looking in the window, I saw no changes. So I think that any sort of interior renovations were likely very subtle. And in most cases, the majority of renovations required these days have to do with data. Every time a new user moves in, you don't reuse the data cabling, you strip it out and start all over. I would suspect that that's the major cost. It's the major cost we see in most all interior alterations. In addition to code upgrades that are required for air handling equipment, and barrier-free access.
Last question. For the brief that you submitted for the 2020 cycle versus the brief you submitted today, what changes have you made to your valuation? Is it the same valuation that you sought then that you're seeking today?
Just a minute, I'll have to find the answer to that question. I don't have, let me get to my electronic copy here. No, it's a different number.
What was the value that you were seeking in 2020?
1,139,000.
Okay, so essentially roughly the same value. What was the cap rate?
No, we adjusted the cap rate downwards from 8.75 to 8.5, and I think there's an adjustment on shortfall. I see that there's an adjustment on shortfall as well. So we recalculated.
But essentially, you're pretty much asking for the same number this
time. No, we reviewed it, and I think we're in an arbitration or a litigation quasi-judicial setting, and I don't think we can use the words essentially the same. We took another look at it, and we came up with a different value. It was just what we did, the review, and it was a 47-page brief, and the one we submitted for this is 87 pages. So we rethought the situation.
With all due respect, Mr. Neufeld, most of the increase in paperwork or in your brief is because of the application that Jamie Mercury received.
Is this a question?
That's all the questions I have.
Well, just a response to that, what does that really matter?
Thank you. We're going to move on to the next question.
No, I have no questions. Thank you. I think I have a picture.
Okay, Cynthia.
I also have no questions. Thank you.
And neither do I. Anything in summarization, gentlemen? Rocky?
I think I've covered it, and unless Mr. Mercury has something to say.
Nothing further. Nothing further.
Mr. Pools?
No, I think we covered everything.
Okay, thank you very much. That will conclude that matter. Take a break, fine.
Yeah, before we take a
Oh,
break.
1 second.
Sorry, just before we take a break, Trevor, we're gonna just deal with some quick properties first. It won't take long, and then we'll deal with Trevor. Thank you.
So take a break.
No, we'll
take a break and
then deal with her.
Yeah.
Okay. And we'll call the meeting back to order. Swear, sit in, please.
Mr. Story, can you state your full name for the record, please?
Sydney Earl Story.
Do you affirm that the evidence you're about to give at this hearing should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
So we're going to start with 124th Street. Sid. Jeremy, I think Sid wants to just say a word. Is that okay with you?
Yeah, that'd be fine.
Sid?
Yes, what my request for this morning is confirmation on 1770 King Edward and 120 Ford. 1440 Plessis has been withdrawn, and confirmation as well on 41 Westbrook. So there's 3 files left with like confirmation.
You okay with that?
We need to.
Yes, are you going to be okay with that, Jeremy?
Yeah, that's fine with me.
Okay, you want to read them on the record then? We'll start with 124th Street first. Just read it on the record.
Sure. Bear with me.
Yeah.
124th Street, roll number is 1209307600. The 2022 assessment cycle we have a value of $1,229,000. That be enough?
Enough. And then the
What do
next
you
one
need?
is Westwood. 41.
Okay. '41 Westbrook. The roll number is 120938005000. For the 2022 assessment cycle, the assessed value is $2,385,000. Again, $2,385,000.
Thank you. And the last one will be 1770 King Edward.
Roll number is 0709189350. Address is 1770 King Edward. We have for the class 60 portion taxable $4,049,000. Again, $4,049,000. For the 40 class 40 exempt status, we have $392,000. And for the 40 institutional school tax exempt, we have $585,000 for a total value of $5,026,000.
Thank you, gentlemen. That will conclude those matters. We'll
Thank
then
you, gentlemen, ladies.
see you later, Sid.
Have a good
Have a
weekend.
good day, Sid.
We're going to move back up to 180 Lawson Crescent. Trevor, come on down.
Lost. Oh, shoot, did I get
It looks like it. We're getting you back.
just give it a second. These things all around. That's why I didn't know that. There you go.
So, you're back. Jeremy, you ready? Oh, we're gonna swear you in first.
Sorry
That's
about
okay. I didn't think I was picked up, but I'm back. I missed a bit of what. So we're doing 180 Lawson.
That's correct. We're gonna swear Trevor in first.
Mr. Smith, can you state your full name for the? Can you state your full name, please?
Trevor Smith.
Do you affirm that the evidence you're about to give at this hearing should be the truth, the whole truth, and nothing but the truth? Thank you.
Jeremy, you're up.
The year starting is for the 2021. We have a supplemental assessment for a new property that was developed at this location. The civic address is 180 Lawson. Roll number is 10014100000. The assessed value is $6,273,000. It is for a complete car dealership, a luxury dealership. The actual year built is for 2001. There's 2 stories on it. It's a car dealership, so there's no space. We have a land area of approximately 183,000, a plan area of the building of approximately 29,000. So for a land to building ratio of 6, little over 6. The gross leasable area is 33,905 square feet. As we go through the property, the best place to start would be the pictures. We can start on page 9, my brief.
Page 9, you said?
Page 9. It's what the site formerly looked like. It was an industrial yard, you know. It was redeveloped. The permit is attached. The permit value was for approximately $6,900,000. So that would be for, bear with me here, I lost my page. That would be for the dealership component, not including the purchase of the land. So as we go through, we see property where it was. One property. There was two properties developed adjacent to each other, close to each other. One was Birchwood Jaguar Land Rover, and the other one was Birchwood Lexus. So next page would be the subject property on page 12. As we go through, this is the Jaguar Land Rover dealership. The pictures are as such. These pictures, I haven't been in the property. These are file photos from the inspection that put it on the roll. As we can see, it is a high-end luxury dealership, as what Jaguar and Land Rover are. So we see the front shop, I should say the front dealership area, the showroom area, and as we get to the back, you see the shop area, the service area. As you would expect, it's highly modern. It's brand new. So I think that covers the entire building. There are several pages. I'll let you go all the way through that. On back to the valuation. So as long as we're all cut up, we're all good with the pictures. Can I move on? We're good. All right. Page 3 is our rent comparables. I'm pretty sure the panel has heard this argument before, so we're just gonna kind of go through it again. Car dealerships are owner occupied. There is virtually none that I'm aware of that are owner occupied or that are tenanted long-term investment type leases. They don't exist. They're always owner occupied. So we cannot use owner occupied or car dealership leases. They don't exist. So we have to go out to the marketplace and encapsulate what the rent would be should an ownership group here go out and choose to be in a retail location and acquire a building on a site similar to what they have. We're using a bit of economic substitution here. So what we do is we go and look into the marketplace for similar properties and similar locations, and then closest similar properties are your big box store type properties. They have large land to building ratios. They are typically slab on grade, steel frame buildings, bit of masonry, mez space usually to accommodate bit of storage area in the back to house what they have before they put it out on the floor. So this is the marketplace that we're selecting. It's not a new idea. This goes back to a few orders, even predating Unit 90 at Point West, which is the most recent order, and I quote recent because it's 2004, I believe. It's quite a ways back. So when we look here, we know that if they were to move into these particular kind of properties, these properties here are very bare bones. They're just walls. They don't have the showroom finish. They don't have all the build up that a typical dealership would. And if you would be renting those out, you'd be needing a higher rate than a building that from an owner. You would need a higher rate of return than what was just a bare bones walls and mez in your typical retail type environment. So when we go through the comparables, we're listing 27 comparables, starting from 2013 leading up to 2017. There's about 506,000 square feet. We have an average of $18.86, weighted average of $18.05, and a median of $18.29. So that's a very tight analysis. Again, it's a good analysis. The numbers are where you would expect when you're reviewing a marketplace that's lining up like as such. Below that are just a few comparables that we have for auto type tendencies. Now, on this, to be full clear, 1284 Main Street is a lease for 22,000 square feet. It is on Main. It is an MPI center. So they have, you get a car, there's a garage area in the back of it, large garage area in the back. I've been in the building. There's an office area up front. And yes, there's a bit of, I don't even want to say basement area. It's not really a basement area. It's the way the windows work. It's office area that's below grade, best way to phrase it. That didn't incorporate into the 22,225 square feet. So that rental rate should drop a little bit from the $90.50. The Portage Avenue properties are automotive related. And then 2535 Pembina is a property that we dealt with extensively. It is Pattison Toyota. It was over on, spoke there. Pattison, not Toyota, that's one on Regent. Guys.
You're talking to Subaru dealership.
Yeah, sorry. I apologize. You've heard this argument before, I hear. So basically, this was an agreement to purchase. They rented the property out for a number of terms with an elevated market rent. I contacted the property owner. They contacted or the contact person on the sales questionnaire that we reviewed the information that came back from the sale. This property was rented with an above market rent with the intent to purchase. Basically, what it was test drive of the site, so to speak. Basically, we could sell and you can develop the economic opportunity on the site. They were intending to purchase. The property owner did not have an option not to sell. So it was at the option of Pattison to buy or walk away at the end of each term. At the end of the first term, they purchased the property with an agreed upon amount that was when the onset of the lease occurred. So they had an appraisal done on the property. So that's why there's a bit of an elevated rent. To stress, we are not using comparables 20, 29, 30, or 31 to derive our valuation here today. It's just the residual of what we have to work with. There really isn't much in the marketplace, as I stated. Everything is owner occupied. So from that, we go to the income analysis, which is on page 4. It's 33,000 square feet, or 33,905, so almost 34,000 square feet. We have $13.90 applied to it, which produces a potential gross rent of $471,280. The vacancy we have applied to it is 2%, which gives us an effective gross income of $461,854. Expenses again at 2%. The argument here is 7, the additional 5 that was in contention from tax owners and agents. Again, I'm not going to speak to that any more than that because we've already done that enough. The board already knows our arguments. So shortfall is at $6, which produces a net operating income of $448,548, capped at 7.15%. Gives us our capitalized value of $6,273,399, and rounded, of course, that's $6,273,000. So that is the general workup for vehicle full service dealership. With that, I think it's reasonable. It's based on the retail environment. The next closest apple or orange to this apple, if you want to look at it in those terms. And essentially what it works out to be is if this ownership group or another car dealership group would go out into the marketplace, where would they be able to go get a similar building in a similar location to deal with a similar use and acquire that rent for someone to develop their site? You take it from the retail marketplace. So with that, I think it's fair. That's the best information we can present to come to the value that we have today.
Is that it? Questions?
Yes, thank you, Mr. Chair. Mr. Pohl, I don't say this often, but you seem to have outdone me on the photos in brief here today. It's not sure how many pages there are there.
I didn't take them. Like I said, we had a recent inspection to put the building on the roll, and we take pictures. So yeah. They're at the luxury of my use.
Sorry, just thought I'd lighten the mood slightly. Okay, let's look at page number 4, I guess, the income workup for the property. Valuation for the subject property is all model based, I'm assuming.
Correct.
Looking at the vacancy. So as you had mentioned, we're not looking at leases from other automobile dealerships, et cetera, here today. As far as rents, et cetera, go. Just wondering where the 2% vacancy was taken from. Is that an overall retail vacancy? Is that? Just wondering if you can supply for the detail.
Combination looking at what the actual rent, or I should say, the actual vacancies are in the actual subject property, like populace of car dealerships, but also with retail. So. Okay.
And I think you had mentioned just in looking at page number 3, the city's argument as far as valuation goes is because there are essentially no arm's length first run automobile dealership leases on the marketplace, that you've made a substitution and you're looking at essentially big box structures based on I guess the size and basic structure of those retail facilities. Is that accurate?
Correct.
Okay, looking at page number 3, the lease comparables at the top that have been used. So these are the big box comparables then?
Correct, yes.
All right. And
retail.
Okay. So I did look through the 27 comparables that are here then. And I'm not going to run through them one by one, but with very few exceptions, they're located in the Polo Park Power Center node, the IKEA / Seasons of Tuxedo Outlet Mall Power Center section. And then there's one or two on Crossroads Shopping Center at Regent and Lagimoje, the Power Center node there. Is that fair to say? That's encompasses what we're looking at?
Yes, it's not particular to any given location. This is the global Winnipeg marketplace, but these are the leases that signed up approaching the reference date. I could have run in others, but I did want to stretch it past the 5-year typical term that would occur in the marketplace. So it's not that we are selecting those particular regions. It's just that those are the regions that leased up. If we brought in older rents, we would stretch the comparables past 27, and that point it's getting the rent a little too far away from the reference date. So.
All right. So in terms of the tenancies that are in these particular comparables, I'm just going to run through a few here. So we'd be looking at tenancies such as Staples, The Brick, Ashley Home Furniture, Michael's, Giant Tiger, Safeway is one, I believe. Home Outfitters, Sport Check, Best Buy, Bed Bath & Beyond, Old Navy, Mark's Work Warehouse. This is the type of tenancy that we're looking at?
Correct. Typically national retail franchises in retail environments is exactly what we're looking at.
Okay. And just to clarify, so number 15 there, 817 St. James Is that the Silver City Theater that we're looking at there? 25.50 per square foot?
I don't have my key out in front of me. Sorry, I usually don't get asked that question. I don't believe I would have put a theater into that.
It was the only one with that address that I could locate. So I just wanted to clarify whether that was indeed.
If you can give me a minute, I can. You can give me a minute, I can. Just bear with me here. Luckily, I'm working in a virtual office, so I have access to other things. Okay. Bear with me here. Comparable 15? Comparable 15 is
Yes.
Comparable 15 is Pier 1 Imports. Pier 1 Import would have been just in front of Polo Park, the box store they put in front. I guess it's across from Red Lobster on the obviously in the Polo Park.
Okay. Okay, so as you had mentioned, these are all national level covenants, franchises, etc., that are being shown here as comparables.
Correct.
And they're all located in these power center nodes with other supportive retail around. Is that correct?
Correct.
Okay. You had mentioned that I guess the last four comparables are not really being used, the automotive ones.
They're there for reference, but I mean, I have to survey what we have to pull from the automotive end of it, and there isn't a lot. So.
Right, and I'm in agreement on that. Certainly,
yeah, I have to try and show what there is. That way, I can distinguish. We can move away from. I mean, if I could bring in even 5 or 10 car dealerships that are full service rents, we would be looking at this. But every time one pops up, it's either a short-term gap rent or it's something like what we see here. So.
Yeah, absolutely. Fair enough. I just want to discuss one of them, comparable 31, 2537 Pembina. You had mentioned that this is the Jimmy Pattison Group leasing out 2537 Pembina from the former owners, the Thompson family.
Correct.
And you're in agreement that it's acknowledged that they were paying an above market rate, and that they had in their contract an option to purchase the property at the end of their lease term at an above market value.
Correct.
And the lease start here is.
They had the purchase. They had the option to purchase at each one of the end of each term that they were involved. They purchased it at the initial end of the first term.
Right, so. And the lease start here is in 2012. So, in looking at that, the dealership continued as Frontier Subaru rather than Jimmy Pattison Subaru, correct?
I believe so. Yes.
So they would have taken over the operation of the business at that time, rather than instituting their own dealership at that point.
Bear with me here. I give you the exact information. This is straight from the information that I inquired with this sale. 2537 Pembina Highway, purchased for $3 million. Dated January 16, 2012, between Frontier Management Incorporated and Tiger Thompson Holding, and Frontier Acquisition, the tenant. One was the landlord, one was a tenant. The term was between January 16, 2012 to January 15, 2022. Renewal option size with renewals for option to exercise. Rent was $240,000 per year plus operating expenses and taxes, so it was triple net. With an option to purchase that was exercised on January 6, 2017 at the end of the first term. Closed on March 1st, 2017. So that purchase price was already negotiated, entering into lease. It wasn't like it was decided upon later. So contractually, that's what it would have been. The property was leased on an above market rent with the intent to purchase. Purchase price was based on an appraisal that had been completed around the time of lease. Was entered into. They did not provide a copy of the appraisal. And the price was for real estate only and did not include the cost of the value of equipment, furniture, or etc. They already were the tenant. They purchased the property. Realty only. So I hope that answers your question in full.
Yes, certainly. So I have, these are always difficult. I don't
and it's just to work clear, that's straight from the Patterson Group.
Yes. So I have, I guess I have some rebuttal. I don't have anything submitted. It's more of a verbal rebuttal. I don't have this information in my brief, but I do need to speak to it briefly.
I guess you do your rebuttal.
However you want to do it. I'm just asking how you prefer to do that.
Do it now.
If you wanted to.
Yeah. Do your rebuttal now, and
We've placed a weight on it, we think is
Certainly.
you're going for it now. So do your rebuttal.
Okay, I'll be brief. As mentioned, the lease that was struck was at an above market rate. Basically, Jim Pattison Group Auto Dealers was looking to enter the Winnipeg marketplace, and so they approached the former owners of this property and of the Subaru dealership, which was the Thompson family, and the deal that was struck was that in order for a new dealer to enter the market, they would essentially need to take over an existing dealership, and essentially that dealer is giving up their business and their right to continue on. So in order to do that, there has to be an incentive for the existing dealer. So the way that this was structured, and this is taken from discussion with the Thompson family itself, was that there was an above market lease rate struck so that the owners would be paid an above market rental rate for the dealership for the time that the property was leased. And at the end of that term, there was an option to purchase at an above market value rate, so that they would essentially be paid out for at an above market level of compensation for giving up their dealership. The Jimmy Pattison Group did purchase the property at the end of the lease term, and immediately moved the Subaru dealership to the Waverly Auto Mall, which was their intent all along. So that particular location is very cramped in terms of land, etc., and it's also not ideal in that it's not ideally located as a dealership. So the intent of the Jim Pattison Group was to get the dealership and then move it to where they wanted it to be, which was at the Waverly Auto Mall. The property at 2537 Pembina has subsequently remained vacant aside from there is a student housing building that's been built immediately adjacent to it, and there's a temporary use in the property as a leasing center for the student housing building next door. But it hasn't been subsequently leased as a dealership or sold on the marketplace. So that is the information that we have on that particular transaction. That is what we were told. I'm open to any questions that there may be on that rebuttal.
Do you have any questions on the rebuttal before we go any further? Mr. Pools?
No, essentially it highlighted exactly what I stated. It confirmed that they were always the tenant and they purchased the real estate. So basically states what it stated. So
It won't be there for long.
I have no further questions.
Cynthia, do you have any questions of the assessor?
No, I do not. Thank you.
What is?
Yeah, I'm just looking, I was trying to read the permit. What date is that permit on page 10?
Of my brief?
I think you said 6.9 million. I was trying to read this and what's the date? Oh, 19 issue date. Okay, I was trying to see. So it was in 2019, I see here, and 11th of
11/8, 2019.
of August.
That would have been November 8th, 2019.
Okay. And do we know?
And the value was $6,900,000.
That's what it was. So do we know when that work was completed, or we don't?
Well, it would have been completed in 2021.
221?
Went on the roll in 2021. That's why we're here today for the
Supplemental. That's why we have it today as a supplemental. Correct?
Correct. Yes.
Yeah, I know the rent comparables are difficult, but I just have a quick question here. On French word here, economies of scale, this is 34,000 square feet. Would that affect the rates and the comparables? Because I was looking at they're all pretty well, except number 18, I think, who's 36. They're all, oh no, there's another one at 34, but they're all a little lower. So would economics of scale have an effect on making it somewhat lower than the comparables?
Sorry, we're breaking up a little bit there. I think what I got from your question was, do you think economies of scale would make it somewhat lower because of the size factor? Am I correct?
Yeah, that's my question. Not very clear.
Sorry, I'm
sorry.
That's okay.
You just got to take your turn, okay?
Okay. So we're all working in a virtual office. I get it. It's no issue. Basically, if you look at it from an automotive perspective, what I've noticed in the marketplace, all smaller dealerships have had large renovations and additions put onto them, or basically some dealerships have moved away out of older dealerships and created new properties. There's quite a significant amount of new stock being built. If you go down region, if you went down McPhillips, like they're putting in, if you go down Kenniston, they're putting in new dealerships at a much larger area than they used to. What that speaks to is the auto manufacturer makers, and obviously from hearing the tax agents over the years, and also reading the news articles regarding the local marketplaces, you need a larger building to attain a franchise. You need more economic opportunity on that site to drive and sell property, to house property, to serve, or to sell vehicles, to sell service vehicles. So for car dealerships, is more valuable, and if they were to rent, having a larger dealership. So it actually works a little bit different for, it would, if they were to rent, it would work a little bit different as far as economies of scales. It's more desirable to have a larger building, just simply because you make more money. But if you look out in the marketplace, as far as big box stores, yes, there's a bit of economic, or I should say economies of scale, where it does slide down a little bit. So these are not identical marketplaces. We have to look at it for what it is. When we see the rent being at $18, I didn't match it. I didn't say it should ask for an increase to it. We're still reviewing the marketplace. That's a model-driven rent. For now, I'm fine with the value that was produced. I think it's reasonable for now. We are entering into, and maybe the board isn't aware of, we are entering into a large series of appeals for car dealerships that I'm part of, or heading kind of thing. It may turn out that we will be seeking increases for rent once our complete analysis is done. We're still doing those stages. So for now, I think if you're asking me, why am I not asking for about an $18 rent? Because that's what the comparables are saying, and versus the $13 or so range. I'm fine with the $13 range at this point in time. So
Okay, thank you, Mr. Chairman. That's all for me.
And I've got no questions. Let's get on with your presentation. Trevor?
Okay, thank you. Thank you, Mr. Chair. Just to begin, I'd like to explain the difference, I guess, between big box retail structures and leases, location, versus auto dealerships. So when we look at big box retail, they are almost by definition located in power center nodes. So they are either on pad sites or in an inline formation where you have kind of an outlet mall where you have big box store connected to big box store connected to big box store with lots of parking out front, and various pad sites of restaurants, etc., and other retail uses on site. This is how modern retail has gone. This is where people do the majority of their shopping, and it obviously is of the most value to retail tenancies to be located in properties such as this. They want to be located in close proximity to other retail users in order to drive the most traffic through their stores. That's why these properties have been developed in this way, and that's why they're in demand by tenants, and obviously that's why they can charge the higher rents that are charged for these facilities by the landlords. So from that perspective, looking at big box retail, yes, the rents are going to be significantly higher than what you would be able to achieve in a dealership location. Dealerships are not located with significant other drivers of business to them, aside from potentially other dealerships in some locations where there's an auto mall, etc., present. But that's a thing to itself. The dealerships again are not on sites such as this, and would not demand the same level of rent as you would get from a big box store on a power center node owned by a national and or international level landlord. So looking at the structures themselves, big box stores, are they, steel, slab on grade, etc.? Yes, they are. They are, however, significantly different from the subject. They have very large selling floors and relatively minimal stock areas at the rears, with one or two loading doors at the rear in order to bring product in. Dealerships, automobile dealerships are specialty use properties. They're not designed such as that. They aren't selling product off of 90% of their square footage. You have the quasi showroom / office area at the front of the building, which is typically in the order of 30 to 40% of the overall square footage of the building, with the balance of the building being automobile service area at the rear, often with obviously multiple access doors for the automobiles to access the facility itself, to be brought in and out. And that's more, the development of that area is certainly not like big box stores. It's slab on grade, but it's unimproved. We're looking at concrete flooring and open deck. There's really no comparison to the level of finish that you would find in a big box store. Hopefully that's clear enough in terms of the differences between the two. We don't see a direct comparison being valid between big box stores and automobile dealerships. So let's move into my brief itself. Obviously, cover page, we have a picture of the exterior from the front of the new dealership. This is the Birchwood Auto Group. It's their new Jaguar Land Rover dealership. It was constructed, finished construction in 2021 and was opened officially in summertime this year. The page number 3 gives us a bit of background on the property. Obviously, all the standard things, roll number, address. We have the ownership there. Zoning for this property, M2. Another point of distinction between the subject property and big box retail, we're not sitting on a commercially zoned property. We're on an M2 zone property, so that does limit the development that can be done in these particular this particular zoning classification. From that perspective, you can't directly take a Staples or a Home Outfitters or a Sport Check and move them directly into this facility, as they wouldn't necessarily meet the zoning requirements to be located on a site such as this, being zoned M2. Our site area is 4.2 acres, and we have a land to plan area ratio of 5.39 to 1 based on the main floor square footage of the property. So a couple of things to keep in mind as we move through this. First of all, number 1, automobile dealerships are specialty use properties. They're not easily adaptable to other uses, either through zoning or through the structure themselves. Number 2, we have a significantly changing automobile industry. This comes up on my page number 11. And number 3, we have a number of decisions on brand new automobile dealerships from this particular board that give good guidance with regard to the subject property under consideration today. So on that note, I'd like to take us to page number A1. That is the first page in the addenda, labeled at the bottom of the property. I'll just wait for everybody to get there. A1.
After what page? After what normal page?
It would be after normal page number 29.
Okay, I can move it quick.
I could, and then I move it too far.
Yeah, well, that's what happens. That's why. Well, I'm getting there.
Gotta be a better way than this.
Oh, yeah, I can do that.
Which one are we going for?
A1.
A1, he says.
Here, I'm there now, border revision.
Okay, so the property we're dealing with today is 180 Lawson. It's the new Jaguar Land Rover dealership by Birchwood Auto Group. Birchwood also developed 200 Lawson. This is the new Lexus dealership. It's located immediately adjacent to the subject property, to the south of the subject. Same access, etc. Very, very similar in terms of development size, etc. And that property was developed immediately before 180 Lawson. So it was finished in 2020, late 2020. And that particular property was under appeal before the Board of Revision, represented by myself. You can see the decision of the Board of Revision on A1 there. Decisions based on the applicant's net operating income and a 7.5% cap rate. Following that, on page A3, I've given you the cover of the brief and then our workup on page A4. So 41,000 square feet, similar to what we're dealing with here today. Rental rate of $1,250, vacancy of 5%, expense allowance 7%, shortfall of 6%. And a cap rate of 8% is what we were asking for. So the NOI was developed based on those points for the decision. So that's a brand new dealership, immediately adjacent, developed by the same property owners. Just south of that, the new Mercedes dealership is located at 1400 Kenniston. This property was also recently under appeal for the 2020 taxation year. Again, brand new development, similar size, perhaps slightly larger. And as you can see from the decision on page A5, it's based on an adjusted NOI, but also a cap rate of 7.5%. And then following that, we have the workup from the appellant for that property as well. In addition to that, I would note we also had 2420 McPhillips Street under appeal. This is another Birchwood property that had a supplemental assessment on it because it underwent renovations. And similarly, the decision for that is shown on page A8, based on applicant's NOI and a 7.5% cap rate. And then we have our workup for that shown on page A13, again, based on a $1,250 rental rate and all of the other parameters remaining the same. So that gives you some background with regard to our approach to these newer properties, or one that has been extensively renovated, as well as the Board of Revision's existing decisions on those properties. Let's move forward with the valuation itself. Leasable area for the property.
What page is that going to be on?
Sorry, page number 3.
Thank you.
We can take ourselves back close to the beginning there. Page number 3, we have a main floor area of roughly 29,500 square feet. There is mezzanine, obviously, of 4,475 square feet, and a total leasable area of just under 34,000 square feet. Following that, we have photos of the property itself. It is newly built, so you can see the level of improvements for the subject property, extent of the service area on page number 6. It's actually slightly larger than that, as there's a drive-through section in behind the office. Some mezzanine office on page 6, wide open. Mezzanine space on the top of page 7 for both the lunchroom and some storage area. And then some exterior shots on page number 8. So that gives you an impression of the property itself. we can move on to the site. Site is shown on page number 9. Unfortunately, there is no newer aerial to show you. This is the prior development on site when the property was purchased. You can see that there is no direct frontage on Kenaston, or no access points off of Kenaston. Access is from the rear, from Lowson Crescent. The building is built close to the front of the frontage on Kenaston, with the rear of the property being mostly parking close to Lowson. The property location, page number 10, you can see the aerial there. If we look where the red dot indicates, you can see that is where 180 Lowson is located. 200 Lowson immediately south of that, and then just south of the roadway across Kenaston there is where 1400 Kenaston is located. That's the new Mercedes dealership. So essentially 3 dealerships in very close proximity, and I've provided you with the details of decisions on those. The location itself, if you move south of the 180 Lowson significantly across the train tracks, you come to the power center node around Kenaston and McGilvery, where Smart Center, etc., are located. Subject property is not in that location. We're not surrounded by other significant drivers of retail type traffic. If you look at the location of the subject, on the other side of Lowson, we have a metals recycler with large exterior storage of scrap metal and various other industrial uses along that Lowson stretch. On Kenaston itself, there is flex space warehouse built on the other side of Kenaston by Terracon, and as you move north, there's a cement manufacturer, and then you get into the IKEA and Seasons area. So we're solidly located within the industrial section of that stretch of Kenaston. It's not a power center node that these properties are located in. Let's move beyond that. As I'd mentioned at the beginning, the automotive industry itself is going through significant changes. If you look on my page number 11, we have what I've titled an automotive industry overview. I'm not going to run through this bit by bit, but I'll just read you the first sentence here or two. Industry is undergoing a period of uncertainty and revision driven by a number of factors. So these factors are the rise of online shopping. Everybody looks online for cars to start with now. They do all of their research online, and then they go and try it out when they're ready to. That's the typical methodology. This leads to less need for dealerships, certainly less need for the number of dealerships that are out there. Number 2, distribution centers. The reaction to this has been by the automotive brands themselves is to realize that they don't need all of these dealerships. They need less dealers, but they need bigger dealers. Functioning more as a distribution center rather than for somebody to come down and see what all the various types of vehicles they could buy are, try them out, etc. They know what they want when they go there if they've already done the research. So the reaction to this has been to shrink the dealership footprint in the marketplace. They may not need four branded dealerships now in a city. They may need 2. Beyond that, we also have changes such as Amazon entering the marketplace, certainly in the European sphere, and they're now entering the North American sphere as well. Amazon's model obviously is to drive the lowest price, lower price, and faster delivery. That is their model, and that is what they are supplying in the European market and moving into the North American market as well. So what is the end result of that? Again, less need for dealerships in the marketplace. So what then is the value of these dealerships that have been developed? Beyond that, obviously, we also have significant changes in terms of the vehicles themselves, and we'll see how that shakes out with the rise of electric vehicles versus gasoline, etc., what the requirements for those will be. Let's move on to my page number 12. Another point that I brought up at the beginning, automobile dealerships being special use facilities. So if we look at the top of page 12, I have a quote from the Appraisal Journal of October 1, 1998, the peculiarities of appraising auto dealership facilities, in which they state auto dealership facilities are considered special use or special purpose properties, which means that they cannot typically be assigned other uses. And auto dealership facilities are typically constructed for a specific use and not readily adaptable to alternative uses. So as I mentioned, they are specific to their use based on the structure itself. And beyond that, so you can't typically move a big box type of tenant into these facilities because they will want to be there because it doesn't suit their needs, either from a location perspective or from the structure itself. And then you run into obviously zoning issues where you can't take a big box tenant from a C2 zoning and put them into an M2 use. Typically, they don't fit the requirements. The structures don't lend themselves to other uses other than automobile sales and service. Typical stage for automobile dealerships are to operate one, first of all, as a branded new auto dealership, Honda, Ford, Mazda, etc. Then when they've outlived that particular use and are not considered useful for that by the brands themselves, they then typically evolve into a secondary use as a used auto dealership when they then become obsolete as a branded auto dealership. And ultimately, once this use has expired, typically they will ultimately end up being demolished and the property will be slated for redevelopment. This is very apparent in the Winnipeg marketplace as well. I'll give you several examples. I'll start with one right now that I didn't actually put in here, but we look at 1066 Nairn, which is the formerly Focus Hyundai. Hyundai directed that they move into a new location or a new facility to match their new branding. They put that facility up on Lagimogé. It's bigger, has better visibility, more land for auto storage, etc. The 1066 Nairn location has subsequently been up for lease and sale for well over a year and remains on the marketplace with, from what I understand, not a lot of activity taking place on it. Let's stick with page 12 and I'll run through these quickly. Number one, 3021 Pembina Highway. This was the former Winnipeg Honda property on South Pembina Highway. The owner moved the dealership to the Waverly Auto Mall quite a while ago and was unable to draw any other dealership brand and or used auto dealer to the site. And ultimately the structure was demolished and is being redeveloped for multifamily use. Number two, 1310 Regent Avenue, originally a branded Ford dealership, evolved into a used auto dealership and has now been demolished and is being redeveloped by Birchwood as an auto dealership because, and only because, they have enough contiguous land available for them to develop it. as a new automobile dealership. The site itself doesn't support the development of a new auto dealership because they have all of the adjacent properties. They have enough land available to make it work. Number 3, 638 Portage Avenue, former McNaught Pontiac Buick, began in 75, moved to Waverly Auto Mall in 2003, became a used auto dealership through 2012, and was for sale from 2011 onwards as a redevelopment site. Property now been demolished and is being redeveloped. Number 4, 2537 Pembina, we've gone through this one, it's the Jim Patterson Group. Once they bought the site itself, they immediately moved their dealership to the Waverly Auto Mall location, and the properties remained vacant since that time. Number 5, the Saturn dealership at Point West Auto Mall, Unit 20, developed as Saturn in 2000, became vacant when the Saturn brand went declared bankruptcy. The building itself was obsolete as it was too small, so Birchwood filled the void by putting in a what they called a truck center, selling exclusively trucks out of that facility. It's subsequently become a Birchwood credit location, which is essentially a used auto dealer. Number 6, 3081 Portage Avenue, formerly been a branded auto dealership, evolved into a string of used auto dealers, and interspersed with extended vacant periods. So that is my summary of auto dealership properties in the city that have become vacant for one reason or another, and the life cycle that they've gone through. If we look at on page 13, we're looking at one of the city's rental comparables, this being Michael's at 840 St. James Street, regarding the reuse of automobile dealership property with alternative retail uses. They wouldn't fit in because of the zoning to start with, but let's look at the structure. So you can see at the bottom on the aerial where the Michael's is located, 840 St. James Street, we have a single loading door at the back, and the majority of the building itself is the selling floor for their particular use. In comparison to an auto dealer, simply wouldn't work. There really is no comparison there. So let's move on to the valuation itself. I would agree with the city. There is very few, if any, automobile dealership leases on the marketplace. So how do we appropriately value the subject property? Well, as I've done at 200 Lowson and 2420 McPhillips there, and our other dealers that we represent for Birchwood, you need to look at the structure itself, what it's composed of, and look at appropriate rents for those individual components. So what is the structure? Well, we have a showroom / office at the front of the building for 30 to 40% roughly of the building typically, sometimes with some mezzanine office. And then the rear of the building is your automotive repair and service area. So in order to effectively value the property, we need to look at those facilities on the marketplace and come up with appropriate market rental rates. So that is what we've done in our valuation model. If you look at page number 15, we have a variety of automotive rents for you here. These are typically not first-run automotive dealers. Some of them are used auto dealers, and many of them are automotive repair, etc. So it is the automotive service and repair area that we're typically looking at here for these new auto dealers. So let's look at what we have. Obviously, we have a range of rental rates running from a low end of roughly $6.50 a square foot up to a high end for a Fountain Tire located in downtown Winnipeg at $13 a square foot with a start date of 2018. representing essentially the top end of the marketplace at $13 a square foot. Obviously, the convenience of having your property serviced downtown is significant, as well as downtown property locations such as 123 Fort, given where that property is, also typically driving higher rents. So that would be the top end of the market. We can run through the remainder of these if you wish. I'd point out possibly a couple. Page number 16 actually has a couple of good ones. Number 19 there, 2554 Portage Avenue. This was Birchwood Credit, actually, that was leasing this facility. Was formerly Mercedes before they moved south to their 1400 Kenniston location. Birchwood Credit moved in, leased it at a rate of $7.50 a square foot. It's located on Portage Avenue at the corner of what is the parkway called there? I think we all know where that is located, just over the bridge from Charleswood. In any case, they rented it at a rate of $7.50 a square foot. Doing the work for Birchwood, I have direct contact with them. The location performed very poorly for them, and they did not carry on with the lease beyond the existing term, as it simply was not a location that would work. Number 20, 1322 Waverly. This is the location for Not Auto. Not does not own the property themselves, and it is an arm's length lease, and they are leasing it for $6.85 a square foot. So you have a location right at Waverly and McGilvery in Southwest Winnipeg, pretty prime location, and a high-end used auto dealer with good improvements in their showroom slash office area, renting for $6.85 a square foot for 27,000+ square feet as of a lease date of 2018. So that's a little bit of an anomaly, being at the rate that they're at, but that is what they're paying. The remainder of our leases, as you can see, are typically service repair, and our rates come in that $8, $9, $10 per square foot range typically. I'm happy to go through these one by one if you wish. We have leases for tenants such as Boyd, Fountain Tire, Midas Buffler, Sturgeon Tire, etc. in these lease rates. So automotive, we're looking from that $6.50 range up to a very high end of $13 a square foot. Let's move on to the showroom retail aspect. And I think this is fairly critical, as obviously the city has mentioned it's a new facility, and it's relatively shiny in the showroom section. So let's look at appropriate comparables for this. What we've sought to do is find similarly located properties that are also of a showroom slash retail type of nature. So let's run through these. Page number 17, 400 Fort White Way. For number 1 and 2, we have Enns Brothers and Sky Zone there, leases from 2013 at $11 and $11.90 a square foot. This is just outside the city of Winnipeg, just to the west of the Costco on McGilvery, and that that particular power center area there. This is shown on page number 18. You can see the exterior of that one, very similar to the subject. Not as ideal a location, certainly, I would grant you, but those are the rates that are being charged there. 996 Lorimer, we have a Dynasty Bathrooms showroom / retail location there. 2016 lease at $13.10 a square foot. This is shown on page number 19. You can see the location just off of Sterling Lion Parkway there, in proximity to Seasons and IKEA, and then a shot of the exterior at the bottom of the page. 1290 Kenaston. This is actually located immediately adjacent to 200 Lawson, which is just to the south of the subject property. This is a former industrial building that has been completely redeveloped into retail location. So we have two leases there, both of them from 2016, once the renovation was done. Trans-Canada Brewing, which is both a restaurant and brew pub on site. $12 a square foot for 15,000 square feet. And then we have Lux Barbecue at $12.50 a square foot in 2016 for just under 10,000 square feet. Identical location to the subject property, and significantly smaller in terms of size. Moving on, Superlight Flooring and the Floor Show, located at 1036 Waverly. Very good location, not quite the same level of profile and our surrounding supportive retail, but we have leases there from 2014 at $6 a square foot for, again, showroom retail. 980 Lorimer, shoe retail, 2018 lease, $12 a square foot. Same location essentially as the 996 Lorimer. It's also shown in my my work on page number 22. You can see the location of it just off of Sterling Lion, and the profile of the property at the bottom of page 22. Clearly high-end property. Number 20, South Landing Automotive, $13.75 a square foot. I'm not sure why that one didn't make it into the automotive section. We have another Fort White Way from 2016 at $11 a square foot, showing you no increase in rent at that facility over that time frame. And finally, we have 96 Nature Park Way, just over or just under 16,000 square feet, a flex showroom warehouse, lease from 2017 at $11.95 a square foot. So you turn to page 23, you can see that this is located directly across Kenaston from where the subject property is located in the Terracon development there. So high profile flex warehouse space, and I believe this is a paint, Dulux Paint is the tenant in this particular unit. So 2017 lease, just under $12 a square foot. So we've exhausted the leases out there in the marketplace. I think we've provided excellent comparables with regard to the showroom retail section of the building. We've provided you automotive leases. Our range for automotive is at $6.50 to $13 roughly. And for showroom retail, again, similarly was $6 to $13. What would be an appropriate rate for the subject property? Well, it is newly built. It is in a decent location. It is of quite a significant size. It's over 33,000 square feet. But it's not, we're not talking a retail location. So we're not going to generate what you would get for a big box store on a power center node. So we're at the upper end of the range, all things being considered. We've got 30 to 40% roughly showroom retail, and the balance being automotive. We've assigned an overall rate of $12.50 a square foot. This takes into account also the mezzanine space in the building, which I've shown you a photo of, and is simply lunchroom and office space. Let's move on to vacancy on page 25. I've already detailed the life cycle for automobile dealerships and their potential for reuse. Obviously, they typically go through that cycle and then are not leased out at the same rate, and they can typically take a long time, as shown by the examples that I provided. One current one being 1066 Nairn. The Johnson report, local market report, obviously gives us industrial vacancy rates for year-end 2017 at 7.3% with a 5-year average of 7.3%. Strip center retail, also from the Johnson report, 3.9% with a 5-year average of 4.6. Overall retail vacancy at 5.9%. 2% is simply inappropriate for almost all property types within the city. So based on our look at the dealerships themselves and what happens to them once they become obsolete, we believe that a 5% rate is certainly applicable, and that is what we've used in our valuation. As Mr. Pohl mentioned earlier, we are in disagreement with the expense allowance that City of Winnipeg has used in the current cycle. In past cycles, the city had what was termed a 5% management expense allowance, as well as a 2% replacement reserve. The management expense was always intended to reflect non-recoverable expenses that all owners incur on leased properties that cannot be recovered from the vast majority of tenants in almost all situations. I'm not going to run through my argument here other than to say I'm very happy to answer any questions that you may have on it. All of the material is provided for you there. We provided the basis for why these expenses should be included based on the Appraisal Institute of Canada's guidance. We've detailed what these expenses are on page 26. And I've outlined a study that I was involved in at the bottom of page 26 that covered a 3-year period, giving you a 3-year average of non-recoverable expenses ranging between 11.5% and 12.7%, depending on what was included, with property counts between 45 and 53 over those 3 years. So we've done an extensive study, and indeed it shows that the expenses incurred are typically higher than the 5% allowed. We're simply asking for the reinstitution of that 5% non-recoverable allowance. Shortfall allowance, we've deferred to the $6 that the city has used, and we can move on to the capitalization rate. So again, our challenge is there are no sales of these first-run automobile dealerships on the marketplace for us to examine and look at the resultant cap rate. So how do we appropriately value these? Well, as we did with the determining an appropriate market lease rate for the subject, we look at transactions in the marketplace for both industrial and retail. We don't really have capitalization rates for automobile repair facilities specifically. So our most comparable cap rates would be for industrial in comparison to the automobile service and repair section of the building, as well as retail for the showroom retail. So if you look at our charts on page 27, we have industrial at the top. These were all recent transactions of investment properties in Winnipeg. They were purchased for the in-place income. And you can see the resultant cap rates for those industrial properties. They obviously vary in terms of size and comparability to the subject, but what they do provide is an indication of what astute investors are paying for industrial investments in the city. So our range there is 7%, 7%, 7.2, 7.4, and 8.3% at the high end. So 7 to 8.3%. At the bottom of the page, we have our retail transactions. Again, purchased on the basis of the in-place income. And we have transactions ranging from 7.1%, 7.4, 7.6, 7.5, up to 9.1% at the high end. So that is our survey of investment transactions in the Winnipeg marketplace just prior to the valuation date. We also supply the information of local national commercial real estate brokerages and their publications indicating their opinion on capitalization rate ranges. So we have Colliers and CB Richard Ellis stating 6.5 to 7.25% and 6 to 7.25% for investment grade industrial assets in the Winnipeg marketplace. Again, when we look at the subject property, we're not talking about a property type that typically transacts on the open market. There is no real demand out there for that. Otherwise, we would see those transactions perhaps. What we do have is a specialty use property that has limited reuse for other potential users. So you have a very specific narrow market segment that you can sell to. And typically what we find is that these properties go down through a cycle where they go down to a lower class as a used auto dealer and or repair facility, and then become obsolete entirely and have to be redeveloped. The subject property, we have utilized the same cap rate of 8% as we have on the other properties that I've already mentioned in my presentation here. The specialty use nature, the location, and investment potential of the property all point towards there being a premium on capitalization rate. When I look at our decisions from the 2016 cycle, we were seeing dealerships, or rather decisions from the Board of Revision with capitalization rates of 8.5%, reflecting the specific use of or specific risk to these properties. We haven't seen a significant change in the marketplace, but we have dropped our capitalization rate to 8% for our current valuation of the subject property. So our summary is on page number 28, and we result in a final market value of $4,553,000 based on a market rental rate of $12.50 a square foot and a capitalization rate of 8%. If you move into the addenda already, I've described obviously the decisions at the beginning of the addenda, representing two very adjacent properties that are newly built auto dealerships. And following that, we have a number of supportive decisions for the 5% non-recoverable issue. I have some materials from CBRE and Colliers describing their cap rate ranges. And at the very back of the brief, I provided documentation from various sources on the changes in the automobile dealership with regard to there being essentially dramatic changes in that market, and there being less need for bricks and mortar automobile dealerships in the market, and certainly less of them. So that is my presentation, and I'm happy to answer any questions that you have.
Can I make a request? 5-minute recess?
Now?
Is that right?
Oh. Okay, let's take a short recess.
Thank you.
Called meeting back to order, and we're going to you, Mr. Pools, on questioning. Oh, he's not there? Are you there now?
I don't know. Am I?
You're up.
I'm okay.
Question.
I'll have some questions on the appellant's brief, and then I'll submit my rebuttal.
Okay.
But first, I'd like to start off on I guess page 79, moving downwards. The articles that are attached to that are dated in 2019.
79, you said?
Yeah, they're dated 2019, so they would be post-reference.
Where are we looking? Page
So-
79.
79.
There's no page 79, is there?
I don't know.
Yeah.
I don't remember seeing one.
Well, on his brief, it's actually 850. But if you look at the
Okay,
PDF
okay,
file,
there we
these
go.
numbers, it's
850.
so we had this issue
Yeah.
last time. I'm not sure how the panel looks at
Getting there.
the
Okay,
briefs.
hold on, we're just getting, it's on the addendum.
Yeah.
Yeah.
This is in the addendum, Jeremy?
Yes, it starts with the
Okay.
future of car buying and the death of dealerships.
And 8A, you said?
850.
850.
Is that what you're saying? 850.
850, if that's what you're looking on that physical page.
The future of car buying.
So
That's dated late 2019, which would be post-reference by a significant amount. So it shouldn't be given any weight moving downwards. So the article should be not given any weight. And the date's up on every top corner of the page, so. If we can continue on to the question of the actual brief though.
Go ahead.
So just to confirm, this is branded by Birchwood as a luxury dealership. It is a Jaguar and Range Rover.
It's a new auto dealership, yes.
Okay. We agree that it is a brand new dealership and it does not suffer any functional obsolescence.
Oh, yeah.
Brand new, built to suit.
It suits the automobile dealership purpose, certainly, absolutely.
Okay, perfect. On your page 9, the site description is not current. That is,
I think I already mentioned that.
okay, fair enough. So getting down to the nitty gritty of these kind of properties, and I'll start off by saying, yeah, they're all owner occupied. So it is difficult to bring in full service dealership rents. So I do understand where you're going with this, but for your automotive comparables, just to confirm, none of them are full service dealerships.
No, none of them are full service dealerships.
So it's a collection of sales, repairs, secondhand or used cars, auto related loosely, whatever the best evidence we can bring in, which either one of us, either assessor or agent, really can't bring in.
As you had mentioned, we can't bring in first run branded automobile dealerships at arm's length because there aren't any out there.
Exactly. So perfect. All right. So none of these are national chain or international automakers. So if we go over to your showroom comparables, are any of these retail big box stores similar to what I presented today?
Are they
national, like national retailers and local market notes?
They aren't necessarily national retailers. No, I think for the most part, I've detailed who the tenant is in the chart there, so you can see for the most part who the tenant is. I think the very last one is a national tenancy, 96 Nature Parkway.
Okay, But mainly speaking, like when Sky Zone was around, I used to jump there quite a bit with my little guys. So it was a trampoline park. I believe it's still vacant, I think. And then the rest of them are, you can see 20 on page 20, your 1290 Kenniston. That was a former rototilling plant, a rotomolding plant, one of the first jobs I've ever had. On a side note, if you ever actually do rotomolding, don't. It's not fun and it's not safe. It's a pretty bad job.
So 1290.
It's been converted over to a brewery house now, right?
Sorry, I didn't catch what you said there.
It's been converted over to a brewery house now, right?
Well, the entire building has been renovated to more retail use with a brand new frontage, and it was demising was changed and the interiors were redone, so it's showroom retail as I'd described. The Trans-Canada Brewing is part tasting house restaurant / and then there's the actual production of the beer in that facility as well. And then Lux Barbecue is showroom retail.
Yeah. So in that particular one at 1290, it was a former industrial manufacturing rotomolding facility, and now it got converted over to its current use. So there was a switch of use there. And then the rest of the comparables, none of them are other than Deluxe, which could be considered a national chain. They are a national chain, but that's in a non-retail location, correct?
It's not a directly retail location in that it's not sitting on a power center site. What it is it's on that. Sorry, which one were we talking about again? Nature Parkway?
Page 23 would be 96 Nature Parkway, yes.
Yes, so it is the Flex Warehouse development by Terracon that is visible from Kenniston. It essentially fronts on Kenniston, and you have some quasi-retail uses, but it's a mix of office and other higher end uses.
So basically, they store their paint, they sell their paint. I'm sure there's a small retail outlet there that you can maybe do, but it's mainly the head office and the storage facility.
It is. There's certainly office space as a component of it, yes.
And the land ratio here would not be encompassing to a retail location, meaning drive work on it, large walk up, or site storage for or storage for automobile dealerships if it were.
Yes, it's certainly a different style of development.
Your vacancy, as we both are aware, that is not based on the actual vacancy that occurs within dealerships.
No, there's no market stats out there on vacancy for dealerships, obviously. But what I did supply is. If you go back to my page number 12 and history of some properties that did become obsolete as first run dealerships, you can see the cycle that they go through and the vacancy that they experience. And beyond that, the vacancy stats that I've shown on page 25, both for an industrial usage as well as retail usage overall, indicate that 2% is far too low, and that 5% is certainly appropriate. You'll notice I didn't go to the high end of the range here. We're simply looking for a normalized vacancy to make an appropriate valuation.
Okay, no problem. But just to confirm again, none of the vacancy is influenced by retail.
Influenced by retail?
Pardon me?
I'm sorry, none of the vacancy
is from large, big box type stores in retail nodes.
Well, when we look at the information that I've shown there, the Johnson report statistics indicate strip center retail 3.9, with overall retail vacancy at 5.9, which would include your big box retail power center nodes.
Okay, maybe I'll rephrase it another way. It's not exclusively that big box type vacancy, correct?
No, it's not exclusively, but when we look at big box retail vacancy, obviously they do have issues with vacancy on in those particular developments as well.
Okay, fair enough. Capitalization rate. Clearly, there are no cap rates. There are no rents. That's a non-investment type property as far as typical investment type property. You're using capitalization rates from retail, correct? And you're using the capitalization rates from single tenant industrial.
What I'm doing, Mr. Pohl, is using a range of capitalization rates on both industrial and retail to show what the range being paid in the marketplace is in order to determine an appropriate cap rate. So yes, there's single tenant industrial in there as well as multi-tenant industrial.
So you're trying to come up with the best market information that you can apply to this property, given that there is no actual market evidence or market parameters that we can data mine from it. You're trying to do basically, here's some retail cap rates and here's some industrial cap rates, and you're using your judgment to apply to it, correct?
Yes, so our challenge obviously on both sides is to determine the most appropriate valuation model, and when there is no direct evidence of trades of these particular types of properties that are arm's length, you need to look at what the market is for similar properties and make an appropriate selection of cap rate for this particular property type, taking into account the differences that we've already described. Yes.
So of your retail, how many of these would be considered bigger box type locations and power nodes, retail nodes?
Well, again, we're not basing our valuation on big box retail. That would be the city's model that's being followed. So I didn't specifically look for big box retail sales. What we looked for was true arm's length transactions where the purchase was based on the in-place income, where there was no dramatic change to the property immediately after purchase, etc.
Are there any national chain, national franchises in these comparables?
Yes, there's a number of tenancies that are in these properties that are national tenancies. Yes.
But in a non-big box scenario, so lesser
non-big box, yes. But the same national level covenant.
Okay. Bear with me here. You included a number of orders from before for the 2020 cycle. I'm okay with allowing those in. You can present them. I don't like comparing assessments to assessments from one cycle to another. That goes against case law, but we're here to explore all parameters today. And given the fact that these property type classes, vehicle dealerships are quite unique in the fact that they're all owner occupied, we kind of got to pick the best information we can work from. Last question for you. You're basically stating from your analysis that the risk of holding these type of properties is significant. These type of properties are looking to go have a shorter life cycle, or looking to get out of the marketplace as far as move online kind of thing. Given you represent a large portion of a very well knowledgeable virtual auto group, they're very well knowledgeable. Can you explain why so many dealerships have additions put onto them, and why there are so many new starts, bigger dealerships, larger dealerships occurring within the marketplace? If it's such a risk.
Yeah, absolutely. Happy to do that for you. So the local owners the rights to sell properties such as Subaru or Ford or what have you. They have agreements, obviously, with the brands themselves to carry their product, and they're at the mercy of those brands as far as how those products are displayed and marketed. And part of that is the image that is presented by the facility that they're in. So what we understand from our discussions with local owners is that there's a cycle that the brands themselves impose upon the owners that is in the neighborhood of 5 to 7 years, where rebranding will take place, and the brands force the owners to redo their facilities to represent their current branding. So that will be a whole scale redo, typically of the front end of the building, to portray this new image. And the brands themselves hold the hammer in that negotiation, and that if you're unwilling to do it, well, you don't retain your rights to sell those vehicles. So you essentially lose your dealership. So that is a big driving force as far as how the redevelopment of these properties does take place. As I'd mentioned, there is the shift towards larger and less dealerships out there. So you see the brands again driving larger dealerships as more of a distribution type of situation versus a large number of dealerships in a market. So again, that's driven by the brands themselves and their reaction to the market. So ultimately, that's largely where those are coming from. What you see, I hopefully that answers your question.
No, that's fine. And that kind of leads into when you see a populace of particular type of properties that are all owner occupied, they're carrying that risk. They're carrying that risk inclusive of all the costs that the franchisees are putting, or the manufacturers are putting on them, and they're covering it. And that economic opportunity must be there to generate that, to cover that. So if this were to be a rented situation, you would see that there would be more risk if they could establish leases in place and have someone else carry that risk. Yet it's quite the opposite, where every single one's owner occupied. That would speak to the strength of that industry. That would speak to the strength that if it were to be rented, how much rent could be achieved on those if another property owner was bearing all that cost and risk. So when I'm looking at this marketplace, I'm a little confused to why you think there's a substantial risk or more risk when you see the exact opposite, when the economic opportunity of paying rent versus the ability to leave a property at the end of your lease and you don't have to carry the property is not being exercised. Instead, it's going the opposite way, where basically ownership groups like Birchwood, Vicar, they're consolidating the marketplace and buying up every type of franchise they can get and keeping the owner-occupied property. So it seems to be reversed to what you're saying here today. Do you have any explanation as to why?
Yeah, absolutely. So that's an interesting point. And basically, if you take it back to your starting point there, the brands themselves don't go into selling their own vehicles, so they're not going to go out and they're unwilling to go out and be the sellers of their own vehicles. The history of the industry is such that there's local dealerships that are provided the opportunity to sell those products. So that's simply the structure of the business of that industry itself. That the local representative owns the unit itself versus trying to become a tenant and have somebody else build the facility for them. If you'll notice, nobody else is building these facilities. It's the owners themselves. So we're not seeing any appetite in the marketplace for somebody to put up an automobile dealership for a tenant, either on spec or with a dealership in tow, where they had a tenant, a local dealer that would be willing to go in as a tenancy. We'll put up the facility for you and charge you rent. You don't see that happening because there's no appetite on the side of investors to take that in. They look at the market itself. They see the changes that I've described, the consolidation, the need for update driven by the brands, the need for fewer dealerships in the marketplace, etc. It's all of these things point to increased risk. So when you look at the owners owning the sites, it's both history and the way it has to be, as the real estate investment industry hasn't shown any appetite for taking this particular asset type on as an investment. I don't see any automotive dealership REITs out there in the market.
Okay. I take it a little bit differently. I think the ownership groups don't want to pay the rent that they would have to pay if they would be renter or tenants. They would rather keep that rent that they would pay within themselves and just carry the risk of the properties. And that's what's unfolding in the marketplace here. At least that's how I see it, but that's a difference of opinion. So that's the last question I have, but I would like to get on to my rebuttal information. It's pretty short.
We finish our questions and we'll come back to your rebuttal.
Sure.
Okay. Cynthia.
Don't forget.
You know, this has been pretty. It was a comprehensive presentation and comprehensive questioning. So I think pretty much everything I had has been answered. Thank you.
Good. What is?
Well, I just try to be complicated here. You mentioned 30-40% as like not really used for the dealership. I don't think that's what you said, but you know what I mean. The mezzanine is about 15%. So what's the rest that you're saying? Because usually mezzanine is office, washrooms, there are all kinds of stuff there. So where do you get your figure of 30 to 40%?
Well, so I'm not specifically speaking about this particular building. I didn't work out what the division is, but typically for an automobile dealership, you've got showroom retail at the front and then your repair and service area at the back. And it's in that 30 to 40% range is showroom retail / office, including mezzanine. And then the balance being the service area at the back, right? So for the subject property,
I was just trying to get a bit of a handle where you got your 30 to 40. So
that's what we see in the market. So we've got what here for this? We've got 4,500 square feet of mezz, and then 29,000 square feet of main floor. Some of that mezzanine is in the service area as well. It's not all up front. And the mezzanine doesn't cover the entire footprint of the front area as well. So it would fall within that 30 to 40% of the overall building area.
So the services are included in your 30 to 40%, that area?
No, that's the balance of the building. So of 100%, you've got 30 to 40, that's your showroom / office. And then the balance is your service and repair area.
Okay, yeah. That's the only question I have, Mr. Chairman. Thank you.
I have no other questions, so on with your rebuttal. Mr. Gould.
This is just one order leading back to from quite a ways ago. As the board may be aware or may not be aware, there are a significant amount of outstanding appeals at the municipal level for car dealerships. Roughly about 180, a little over 180, and whatever will be inclusive of this here. I'm sure we'll make it there to push it over 200. Currently, there's 3 test cases that are going to be decided upon to kind of go through. I'm heading that. This is one of the orders that come from my research on it. Obviously, this order predates me by quite a bit. Every hearing is de novo, and we're going to take a fresh look at this at the municipal board, but this is what we have to go on. This order here, order number A02223, is for Waverly Auto Mall. It was not all of them back then were finished. Some of it's vacant land, some of it's dealerships that are done. If we skip down to page 11 of the order, this is for Unit D, which would be Murray Chevrolet Limited. It would be the largest one of them. It's about 56,000 square feet, give or take, back then. This is the board's findings. The board is satisfied that the appropriate method for value the subject properties improved by automotive dealerships is the income approach. Okay, we'll look at all 3 when we get to the municipal board again. We'll revisit it if need be, but they're going on the income approach, and that's what we're using today. The board notes that in previous municipal board orders A2027, the board applied the parameters of miscellaneous retail to the subject properties and applied a capitalization rate of 11%. The board has reviewed the evidence provided by the parties dealing with the classification of the subject and reviewed the classification of the various types of property included in the retail property income valuation for the 2002 reassessment cycle provided by both parties. Highlighted in yellow under that. This is the most important.
May I briefly interrupt? I'm just having trouble tracking where you are.
Page 11.
Yeah.
It should be highlighted in yellow.
Okay, mine's black and white, but.
Okay. So as there is not a specific category designated auto mall, the board has considered characteristics of various classifications to determine its similarities and differences to miscellaneous retail and such retail as a chain restaurants, supermarkets, discount stores, department stores, or big box stores, essentially. The board accepts that the argument that auto malls and the agglomeration of auto dealerships located in different sections of the city results in the auto mall having characteristics similar to regional, local retail with national rather than local tenants, national chain tenants in retail, local retail locations in retail centers. The board is satisfied that subject is similar, although not identical, to large national and international retail properties located in or near regional shopping facilities. That's for cap rate. Cap rate is inclusive of risk, but more and all components to that risk: rent, vacancy, costs to occupy, all of it. So this is the crutch of where we're looking at. So when it's a retail automotive service sale property, they're always located in retail locations. You got to sell. You got to have people come up. You got to store your vehicles on the site. Of course, now a lot of dealerships are having offsite facilities to store because the volume just indicate to do that. It's worth it. But this is where this comes from. They're basically saying we can't go with there is no marketplace even back then. There are a few rents that I've reviewed a number of orders that indicate that there may have been some at that time, but I don't think there were ever really arm's length rent back then. Every time I try and track one down, it seems to be that they're always interrelated in some way. So unless the marketplace, there was a residual marketplace that consolidated into owner occupiers, it probably always was owner occupiers. So what we're hearing from the board here is that the last significant order that I've seen is that we are to use national tenants in retail, local retail environment. So that's where we're focused on. And that's the subject that we're looking at today is a retail location It is a international brand, and we're looking at comparables that I've looked to bring in. So when I look across and I see and I respect the work that the agent has produced and put in his brief, he's trying to capture a marketplace that really isn't there. We're trying to do the same thing we're doing. The focus is not on the right rent information that we're seeing. So when I'm looking at it, it should be national, local national tenants in local retail nodes or power centers, if you want to say it like that. And you should look at the encompassing all vacancy, all the rents attributed to it, come down to the cap rate, not a mixing of stuff to kind of come up with a value. And that's the emphasis that I'm trying to point out here with this order. Hopefully that's enough for the Board of Revision to consider. And that's the position that I'm taking here today. So I don't think the rents that are brought in are appropriate. I tend to kind of go against what the few orders that we have. So pretty clear in that. So I'll leave it at the board's hands, and we'll wait for whatever ruling that comes up.
Anything information? Oh, I have.
Oh, you got a question
I
for
have
him?
either questions or rebuttal to the rebuttal.
So rebuttal to the rebuttal or question?
Rebuttal or question? Hey, that's a good one. Go ahead.
However, whatever you want to term it.
Just ask the question.
Yeah. So this particular decision and document is from 2002, correct?
Here and yeah, 2002.
And the most recent decision on an automobile dealership would be the one on Unit 90, 3965 Portage Avenue at the Point West Auto Mall, which would be subsequent to this time frame. Is that correct? I forget the exact year. 2000.
Early 2004, I believe.
Yeah,
early
so that's subsequent. I don't recall seeing anything with regard to call it the sections you've highlighted here, comparison to chain restaurants, supermarkets, discount stores, and the comparability between auto dealers and that. That isn't mentioned in that decision at all, is it?
No, not in this verbiage. No, this was the second last.
And that would be the most recent decision from
It is one order. It is one order. Yes.
Okay. So I guess my comments with regard to the rebuttal would be certainly each side has the ability to determine what they feel the most appropriate model would be to apply to these types of properties when there's a lack of direct market evidence to apply to them. I don't dispute that the city can look at big box stores on power center sites, etc. That's certainly within their right. What I'm pointing out in my verbiage and discussion of this is that that's fine. They drive those rents in those locations for those national tenants in that agglomeration, and there's a reason for that. And that is not directly transferable to automobile dealerships. So they're not. They can certainly go down that route and use those leases as they wish. What I'm saying is that they're not. We're not looking at apples to apples, and there's a considerable gap between a location of a big box power center, national level tenancy in a power center site versus a dealership in the locations that they're in and the developments that they are.
Can I just have a follow up to your Unit 90?
Are we going to have a debate here, gentlemen?
No, I'm done.
Sorry,
go ahead.
I didn't catch on that.
Sorry, I'm done.
Okay, I just wanted to follow up with your Unit 90 question regarding that their national leases weren't, that verbiage wasn't in there. The verbiage wasn't in there is because both parties relied on car dealership rents that were assumed to be arm's length, and after research, they weren't. Not that I can determine. And at this moment in time, there is none.
Okay, so just,
That's
and
what we're back to.
I apologize, Mr. Paul, it's not your doing by any means, but this, the way these hearings are conducted now, where we have some appellants and assessors in their offices with access to everything versus being in the hearing itself, it creates a disadvantage. So I was simply asking the question. I don't believe they did deal with retail leases in that decision. I don't have the ability to go back and look at that on my computer now and say, well, they didn't do it because they did it this way. I think there's a gulf there that should be addressed by the board in some fashion where you can only address what was addressed.
Was addressed.
Rather than bringing in new material, right?
Okay.
That's my only
Is
point.
everybody done?
I'm done.
Done? Thank you very much. That will conclude the matters for today.
Thank you, everyone. Have a good afternoon.
Thanks, Jeremy.
Thank you.
And Trevor, I like the format of the new briefs. I like your format.
Nice.
Have a good day.